All right, that would be case number 2019 CF 2887. The defendant is Marcus Gates. And who do I have from the state?
Your Honor, so, Your Honor, just generally, the 393 clients, the state actually isn't an official party to the cases.
Okay.
APD is the party representing the state.
All right, so let me get appearances from APD.
Good morning, Your Honor. Teresa Porto with the Agency for Persons with Disabilities.
Thank
Hey, Ms. Porto. And Your Honor, Rachel Farkas on behalf of Marcus Gates. I'm waiving his appearance, which I can also explain.
Okay.
Sorry, so Your Honor, Mr. Gates, I believe that you have the report, the most recent report. However, that does not address what's happened in the last couple weeks. Mr. Gates fell at the facility where he lives and required surgery to repair a broken leg. Since then, he, I guess for lack of a better word, he's very much struggling. The hospital did not put him on the correct medication upon release, so he was living at a rehab facility right next to the hospital here in Fort Walton Beach, but was experiencing some very serious difficulties based on the medication being incorrect. Last week, midweek, had to go back to the hospital and is still there. I think he's been there for over a week now, and we're essentially in limbo trying to figure out if he can go back to the rehab facility. He can't go back to his group home in Fort Walton Beach yet because he needs to recover more from the surgery. So I would actually suggest that we set a status hearing, perhaps, because myself and Ms. Porto and Mr. Gates's care team are trying to figure out essentially where he should go when he gets released from the hospital. I've been in contact back and forth with everybody involved, trying to make sure that he gets the care that he needs. Ms. Porto, I'm not sure when you think we should have a status hearing, maybe a couple weeks, a month?
It's hard to say just based on, I know that he's kind of been back and forth with the process of being in the hospital and those issues. I'd say I believe we need at least 30 days to kind of see where we are with that, unless you want it sooner. Just because I know that sometimes things move a little slower getting answers to things like that. So I don't want to set it too early and then not have any updates and then just have a kind of no update court hearing. So I would say at least 30 days for a status. As far as the annual review, because we are here for that, I don't know if you wanted to hold off on that order since we are kind of in limbo. The recommendation for the placement hasn't changed.
Right, that's what I was just thinking as well, that we can actually probably still file an order per the annual review hearing. He's lived at the same group home for almost a decade, and everything is great. He loves it there. They love him there. Everything's fine. So, and that recommendation for the level of supervision has remained the same. So we can probably file that order. I would just like to have a hearing, a status hearing, I think, like Ms. Porto said, in about a month. I don't want this to fall through the cracks. I want to make sure that we're,
I agree.
that he's in the right spot. Okay.
In the event that we need some sort of temporary order for a placement, just because the group home is not equipped to handle his rehab, and that's why he's not able to go back there, and that's the only reason. So I would agree that we definitely should keep an eye on this until he's through this process.
Okay, so does that mean we need to postpone the annual review or go ahead and proceed with it today? But I would be approving his ongoing placement, but I understand he can't go back to it, so I don't know what that does to the annual review.
Proceed with the annual review hearing. We can still order his placement. He's currently in the hospital, so it's because of the medical issue.
Right,
The placement is still the same.
okay,
Yes, and then we can even set out the next annual review date if your honor's calendar goes out a year. And then we'll just keep an eye on the issue with the hospital and the rehab facility and all of that. That's been the issue.
Yeah, I
okay.
agree.
Then are the attorneys stipulating that I can rely on the evaluation by Dr. Angela Henderson that was filed on October 9th, 2025?
Yes,
Yes,
Your Honor.
ma'am.
Okay, so as to the annual review, I'm approving the report, I'm adopting the recommendations in the report, which is basically maintain the status quo, but of course, this is subject to his current medical condition, and he's not able to return to the home until until he makes some improvements in his
Yes,
current medical condition. So I will set a status on that for December the 16th. That'll be at 9 o'clock Central Time.
Perfect, thank you.
So, Ms. Porto, I don't know if you're on Eastern Time or not. Okay, so 10 o'clock Eastern Time.
Yes, ma'am.
Okay, so this will be a status on his medical condition with his recovery from his injury and
Thank you.
where
That's
he
perfect.
is and
Okay.
how he's coming along. But I'll go ahead and enter the order on the annual review, and I believe you may have already sent one in advance, but I'm not certain.
I have not, Your Honor. I was still working on it
Okay.
this morning, and so I will have that sent over today for a signature.
Wonderful. It must be someone else I'm thinking of that sent one in advance. Thank you very much, though. I'll be looking for that whenever you're able to send it.
Yes, ma'am.
Okay, and let's set one for next year.
Do we want to do the same date that we
The
did?
same date that we just set on.
I think it was
previous-
November 17th.
Yes, it is November 17th, and why don't we set it at 8:30
Yes, Your Honor.
next year? That's November 17th, 2026, and that'll be at 8:30 Central, so 9:30 Eastern, for another annual review.
Yes, ma'am.
And will APD please file a notice of hearing on that?
Yes, ma'am.
Thank you. And for anyone who needs to appear by Zoom, specifically Ms. Porto, it's the same Zoom number that you're on right now.
Thank you.
Sure.
And I'll make sure that Mr. Gates's care team is informed. I'll have my assistant give them a call, since I'm in court all day, just to let them know about the status date and then the next year's date. And we're going to be in contact anyway, so I'll just be
Wonderful.
speaking with them.
Thank
All
you.
right, thank you, Your Honor.
Thank you,
Thanks,
Ms.
Teresa.
Porto.
Thank you very much. Appreciate it.
Sure. All right, I see Mr. Swiatek in Zoom, and I have a couple people in the Zoom waiting room, or one at least. So, Mr. Swiatek, what case are you here on?
I'm here on Asher Hutchinson. It's not on the docket, but you set it for today for status.
All right, let me get that case number from you, please.
It's got several, 25 CF 1201.
Okay. And the others?
One moment, Your Honor.
Sure.
Your Honor, it's 25 CF 1162.
Thank you.
25 CF 1162.
Thank you. Let me just pull those up. Okay, where do we stand as far as the evaluation? I appointed Dr. McDonald on October 17th. I don't know if she's been out to see him yet.
I think that's a matter for the state to answer, Your Honor.
Your Honor, I reached out to Dr. McDonald this morning. The state was actually unaware that Mr. Hutchinson was on the docket for today, so my apologies. I'm not sure if she has gone down to see Mr. Hutchinson as of yet.
Okay.
And I did send her a copy of the order just in case.
I wasn't aware it was on the docket today either. I'm so sorry. Doesn't say that on the clerk's minutes. So, although I did sign an order recently, Mr. Swiatek, allowing you to appear by Zoom, I just didn't see it written down anywhere that we had a hearing today. So, okay, so I will set the case for the next miscellaneous date. Well, it's already set for December the 10th. Why don't we just leave that as the next status date, and hopefully Dr. McDonald will have been there by then.
Okay.
Okay.
I wasn't able to hear the state as to their reply of where they're at on getting Dr. McDonald out.
Because the case wasn't on the docket, the state was not aware that the case was set for today. And frankly, I wasn't either, but, so we're not sure if Dr. McDonald has been out to see him yet at the jail,
Okay.
or the state's not aware. So
Oh,
state will follow up, and we will go ahead and keep him on our December the 10th pretrial docket, but rather than a pretrial, it'll be a possible competency hearing if Dr. McDonald has already seen Mr. Hutchinson and completed her report. If not, it'll be a status on where we stand with that.
okay, very good.
Okay. Thank you, Mr. Swiatek.
Thank you, Your Honor, and thank you for allowing me to appear by Zoom today.
Sure, thank you. And I have someone on Zoom, Maggie's iPhone. Ma'am, what case are you here on?
Marcus Gates.
We covered that a few minutes ago, I'm sorry, before you appeared. So that's already been
Okay.
taken care of. Sorry, ma'am.
Thank you.
Thank you.
Mhm.
Oh, okay, Ms. Farkas is going to contact you, ma'am. That's
Okay.
his attorney. Okay, thank you.
Thank you. Ooh, I'm good at this.
Sorry? You are ready? Or you, oh, come on. All right, Ms. Merrifield, are you here on Gines?
Yes, ma'am, Brady
Okay, this one
Merrifield.
was also not on the,
So
Not on
Brady
the-
Merrifield on behalf of Venetia Gines, it's 23 CF 423. So Judge, I didn't see it on the miscellaneous docket, but in Odyssey, it is on a separate docket.
yes, I have it, I saved my notes from our last hearing.
Wonderful.
Yes,
So we're here on a status update. As the court's aware, Ms. Gines is on a conditional release plan. So just to give a little bit of a framework, so on November 15th, 2024, we appeared before the court. Ms. Gines was found insane at the time of the offense, and she was placed on this conditional release plan. Today's our second status. The court reviewed her progress back in May of 2025. That was the first status on the plan. And then on 11/12 of this year, Ms. Johnson, she's our forensic mental health specialist, she did file an updated status report. Did the court have the benefit of that status?
yes, I
Wonderful.
reviewed it last night.
Wonderful.
So, has the state had an opportunity to look at it?
Yes, Your Honor.
Okay, great.
And the status report does show that Ms. Gines continues to comply with all aspects of the conditional release plan. Ms. Johnson voiced no concerns with regard to her compliance across the measures that are required under that conditional release. Ms. Gines maintains employment in all treatment aspects. Since the pendency of the case, just so the court's aware, Ms. Gines was originally placed on mental health pretrial services. So this all started in March of 2023. Finally, a resolution in November of 24 with the conditional release plan. She maintained compliance throughout mental health pretrial services and has done so on the plan. I am not asking that Ms. Gines be released from the plan, but I am asking for a modification. I do have Ms. Johnson present today, our mental health forensic specialist, if the court would like to hear from her, but I'm requesting a modification specifically to allow Ms. Gines the ability to drive. She has not driven. It was part of her pretrial condition back in March of '23 and has maintained no driving through the pendency of the case. And I just want to reference, so Florida Statute 916 provides the legislative intent for the conditional release plan that she's on, and the foundation for it is that it's providing legal and treatment procedures for persons that have been found to be mentally ill. That falls under the incompetence, legally insane at the time of the offense. And the purpose is to help her understand the legal process, provide appropriate mental health supervision and treatment, while also balancing public safety. So the compliance plan that she has been on has provided those community safeguards, and Ms. Gines has done well. She's maintained supervision, continued with her mental health treatment without a hiccup. I can tell the court that since this case began and Ms. Gines was able to become regulated, constant communication with my office with both her and her mother, who's also present today. So I'm asking for essentially a business purpose license, similar to a person that's charged with driving under the influence. I'm asking that she be able to drive herself for work and school purposes and to continue to provide her schedule to the mental health forensic specialist who can confirm that she is only traveling for those purposes. And the basis for this is that she has had the same employment for more than 3 years in the local area. She does have an opportunity. It's a wonderful opportunity for her to advance. The position would potentially require her to travel throughout the district to different stores. All of those stores are located within Okaloosa County. It is not leaving the local area. She's been utilizing rideshare services to make all these appointments, to meet with me, to meet with pretrial, to meet with the forensic specialist through rideshare services and through her mother. And I think that the framework of this conditional plan would provide those safeguards basically to function as a safety net, allow her to take an extra step in her treatment process while still being regulated under the conditional release plan. I think that this particular growth is exactly what 916 intended, allowing somebody to improve themselves while providing those community safeguards. So I am asking for the court to allow Ms. Gines to have a business purpose style license specifically for work and school.
All right, and what is the state's response?
Your Honor, while the state acknowledges that Ms. Gines has been doing well on the mental health services, the state is strongly opposed to her receiving a business purpose license due to the nature of the incident that occurred and what we're here for. The state just believes that it would be a potential danger, and we are opposed to that.
Okay, maybe I do need to hear from
Absolutely.
the.
Ms. Johnson?
I'm
I'm fine with her being at the podium or
Oh,
whatever.
okay, well, that's
Can you
fine.
step off to the side just a bit?
That's fine.
There we go. All right. Ma'am, will you please state your name for the
Oh,
record?
let me swear in
Yes.
the witnesses. Good morning. I'm Judge Clark. Will you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. You can put your hand down if you'll state your name.
Nicole Johnson,
All right. Go ahead, Miss Merrifield.
Ms. Johnson, where are you employed?
Okaloosa County Court Services,
And what is your position with Okaloosa County Court Services?
Forensic Mental Health Specialist.
And Ms. Johnson, have you had the opportunity to visit with and continue the treatment of Anicia Gines?
Yes, ma'am.
And has Ms. Gines been compliant while she's been under your supervision and care?
Yes, ma'am.
Okay. Do you have any concerns about her continued compliance?
No, not at all.
And are you aware of the current work schedule that Ms. Gines keeps, where she is, what she's doing on a day-to-day basis?
Yes, ma'am.
And if Ms. Gines were able to obtain a business purpose driver's license to go to work and school, do you have any concerns about that, about her being able to maintain communication with you?
No, she communicates very well. I don't have any concerns.
I don't believe I have any other questions. The court or the state may.
The state has no questions.
Okay. All right. So, Ms. Johnson, let me ask, you said you had no concerns about her staying in communication. That was the question, I believe that you were asked. What about concerns about the safety of the community if I were to grant the request for the limited driving to work and school? Do you have concerns about the safety of the community?
No, ma'am. I do want to mention that I strictly deal with Ms. Gines for the purposes of her conditional release, so I can only speak on that behalf. But from my perspective, I don't have any concerns. She's come a long way, it seems, and she appears to be doing very well from what I've known.
Okay. Thank you.
Thank you.
Thank you, ma'am.
Yeah.
Ms. Merrifield, anything further on that
Just
issue?
final argument on that, Judge, just allowing Ms. Gines to expand those abilities within her care while also being monitored, I think does provide safety for the community. Again, I am not asking that Ms. Gines be given a license willy-nilly. It would just be for work and school purposes. We're not even necessarily concerned with that it would save her a substantial amount of money monthly by using these ride shares. It is all based on her continued treatment, her continued good progress. And my argument would just be that, Judge, allow her to do this under the care of that conditional release plan, because I do believe that that will provide safety for the community and a safety net, frankly, for Ms. Gines.
Okay, and I know the state wants to respond, so let me look at one thing in the court file really quickly before we do that. What is the state's response?
Your Honor, the state would just add that Ms. Gines has been on the conditional release plan for approximately 1 year at this point. And like the state said earlier, due to the severity of what occurred, the reason that we're here, the state just believes that it's a potential continuing danger to the community, and the state would not agree with granting a business purpose license at this time.
I just read the first appearance paperwork. And the allegations in this case, and let me just point out that the charge is aggravated battery using a deadly weapon, second-degree felony is one charge, and the other one is resisting without violence. But the facts that are alleged in the first appearance paperwork, it involves driving.
I understand that, Judge, and I would just
That's
ask.
the deadly weapon.
Yes.
Is the
The
vehicle,
vehicle.
allegedly, is the vehicle.
That is correct.
And it was a pretty disturbing set of factual allegations involving the alleged conduct while driving. So in light of that, I'm going to need more information before I can grant that request. And meaning I'm going to need, while I appreciate the testimony of Ms. Johnson, I'm going to need, the testimony was limited to compliance with the program and checking in. And I'm going to need something more, I'm trying to look to see who the doctors were that.
One of them was Dr. McDonald.
Okay.
And I would just ask the court to consider, there are multiple things on the court's docket, in the progress docket, specifically the affidavits that were filed by Mental Health Pretrial Services. I understand the severity of this case. We have certainly we've never diminished the impact that this case has had. But those affidavits do show the court where Ms. Gines was at that time versus where she stands today. And it is a substantial difference, and that is why the court gave her that legal status of insane at the time, was based on that mental health pretrial report and also the analysis from the psychologist.
Okay. I'm seeing Dr. Joseph's, a report was filed on May 31st, 2024 from him.
I believe he would have been the state's expert judge because it
Okay.
looks like I believe Dr. McDonald had the initial review.
Let me find that one. I think I found it. Yes, I see Dr. McDonald's report. That was filed on February 13th, 2024. In light of the nature of the allegations, specifically that they involve a vehicle and driving, and it looks like someone was injured, obviously. Without one of the doctors reevaluating and giving an opinion specifically on this very issue, then I'm not inclined to grant the request.
Understand,
So
Judge.
I'm going to say denied without prejudice to submit an evaluation or to have Ms. Gines evaluated by one of the doctors that previously evaluated her, and then they can speak to that specific issue of driving.
Understood, Judge.
And I'm concerned about safety of the community. I'd need them to address their opinion on that.
Thank you. And in the
Sure.
event that we are able to gather that information, I understand we need to set another status hearing for 6 months. I believe that would put us in May of 2026.
Yes.
With the court's permission, may I bring this back on a miscellaneous docket?
Yes.
Thank
yes.
So I have two additional things for Ms. Gines. One is a travel request that I filed a motion.
I saw that.
And then to reset her on the new status. As far as the travel request, I did file the motion on November the 12th. Ms. Johnson, whom the court heard from, didn't have any concerns about it. I did speak with ASA Giardina. She also had no objection. This would be the second request for travel, and Ms. Gines did act appropriately for the travel that this court granted in June. So we are requesting those December travel dates that are contained in the motion.
That is correct, Your Honor. The state has no objection to the travel.
All right, the travel that's requested in the motion filed on November the 12th is granted. And if you'll send me an order if you haven't already done so. Or do you have one?
I didn't send one. I have a paper copy. Wonderful. May
Yes,
I,
I will
Rich?
sign it, yes. And that takes care of that. Thank you.
Thank
Thank you. I will do that right now.
I use the same language as the previous order so that Ms. Gines is very aware of what's expected of her as far as communication with Ms. Johnson, both before and after travel.
Thank you.
Yes, ma'am.
And I have signed the order. I'm handing it to my clerk. So that's approved.
Okay.
And let me find the date in May of 2026. It looks like that is going to be May 19th of
Thank you.
2026
9 a.m., Judge?
at 9 a.m.
Wonderful.
And we will see you then, if not before.
Yes, ma'am, absolutely. I believe that's
Thank
all I
you.
had on today's docket. Thank you.
Thank you. Mr. Durrell, do you have your other? Okay, thank you. This would be 22 CF 2711, Johanna Dwyer. All right, and the defendant is present.
Yes, Your Honor. We have received a final amended offer from the state yesterday. Ms. Dwyer has asked for some additional time so we can discuss that offer and potential options. I know we recently set an evidentiary hearing for the 20th. I don't believe I'm going to be able to make it up to fully discuss everything with her by then. If we can ask for just a 1 or 2 week continuance so I can go up and speak with Ms. Dwyer about the offer from the state. I've spoken with Mr. Sprouse this morning. The state has no objection to that. I believe there were some emails sent from your office setting that evidentiary for the 20th. I don't know if we've seen a notice yet or if it's actually been added to the docket, but I did want to address that so we're not back here in 2 days asking for another continuance, Your Honor.
Correct. So in negotiations with Mr. Durrell and with other agencies, no one's ready for the evidentiary hearing in 2 days. So the state has no objection to continuing that, and I don't foresee it being necessary to essentially set another date for the evidentiary hearing because I believe that we are very close to a resolution. If it becomes necessary, then I'll reach out to your office to reschedule it.
Okay. I'm not guaranteeing I'm going to accept any negotiated resolution in this case in light of the massive downward departure that was, I don't know what the negotiations are, I don't want to know. I'm just putting y'all on notice of that there was a massive downward departure at sentencing and in light of the history. So,
Could we discuss that at the bench on
Yes.
why there was?
yes. So when would you like to reset Ms. Dwyer?
Your Honor, I believe I should be able to make it up to see her this Friday. So sometime next week should be sufficient. If the court has a date, Tuesday, Wednesday, I don't know the court's calendar, I apologize.
Okay, so would this be for a possible resolution or?
Yes, Your Honor.
Okay,
And of course, if that changes, I will inform the state, we will inform Your Honor. But I believe it should be resolved.
okay. I am going to be in court for possible pretrial detentions. Let me check and see. I don't know if any are. On the 26th, that's next Wednesday. I don't know if we'll have any. I mean, if we don't have any, which is unusual, but if by some chance we don't have any, then I wouldn't be in court.
Understood. Would we be able to tentatively set her for next Wednesday? And then if there are no pretrial detentions, obviously,
Why don't we do this? Why don't we set Ms. Dwyer for the December date?
okay.
And then you're going to go, you said you think on Friday?
Yes, Your Honor.
Okay. As long as we can give the jail a minimum of 24 hours notice that Ms. Dwyer needs to be transported, we can get her here on Wednesday if need be.
Okay.
So if you could let us know by Monday morning, or Friday afternoon if you're able, but if you could let us know by Monday morning that she needs to be brought on Wednesday, I'll have a better idea. Hopefully, there's a greater chance I'll know whether we'll have hearings on Wednesday or not. If I have hearings on Wednesday, absolutely, you can bring it in on Wednesday, bring this case in for a resolution. We would probably set it maybe at 12 noon, so I could do Ms. Dwyer's case before the pretrial detentions rather
Okay.
than after. But I would need to know by Monday, early Monday, so that I can make sure that the jail has, I'd like to give them more than 24 hours notice.
I understand, Your Honor.
So right now, let's set Ms. Dwyer for December 16th at 9. And let me make a note that you're going to let us know on Monday, hopefully before lunchtime, that if Ms. Dwyer needs to be brought on Wednesday, assuming I have hearings, we'll do that.
Yes, Your Honor.
I'm just making a note so I can let Amanda know. And that would be the 24th, November 24th, Monday, let us know.
Okay.
Okay.
I will. Thank you very much, Your Honor.
Thank you. I might see you on Wednesday of next
I'll be
week,
able to
ma'am.
see you, okay.
Thank you, Your Honor. Thank you, ma'am.
I believe that's all I have today, Your Honor.
Thank you.
Thank you.
Okay, I see Mr. Catalinic, I see Mr. Gates.
Take one real quick, it'll be with Mr. Kimball, Your Honor. It's my only out of custody, I wanted to
Which,
give.
I'm sorry, which case?
It's Willie Kimball, Your Honor.
Oh, yes, okay.
It's 22 CF 607, 22 CF 652, Your Honor.
Yes. Good morning, sir.
Good morning. Your Honor, we were able to get restitution taken care of, so we have a plea hearing for the court.
Wonderful. Thank you so much.
Thank you, Your Honor.
Thank you. All right, Mr. Kimball, if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. If you'll just state your name, please.
Willie Kimball.
Okay, are you Willie Kimball Jr.?
Yes, ma'am.
All right, great. You're here in case 22 CF 607 and 22 CF 652, and it's alleged that you violated your probation in both of those cases. Have you had a chance to talk to your lawyer about the allegations that you violated your probation and any possible defenses you might have?
Yes, ma'am.
All right, have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
I do.
Is that your signature on page 2?
Yes, ma'am.
Do you understand you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes.
Are you admitting to the violations of probation freely and voluntarily?
Yes, ma'am.
Are you satisfied with your lawyer?
I am.
All right, I do find that Mr. Kimball has freely and voluntarily admitted the allegations of violation of probation, and I find that he has in fact violated his probation based on that admission. Looks like there was a previous adjudication of guilt in both cases. In accordance with the plea agreement, sir, your probation is revoked and terminated in both cases. You're sentenced to time served, and then the following costs and fees are imposed. This is in addition to anything previously imposed. In 22607, $100 cost of prosecution fee, $150 cost of defense. That includes the application fee of $50. In 22 CF 652, $100 cost of prosecution, $100 cost of defense. And you will have 24 months from today to pay all of those outstanding fees and costs before they go to collections. Once they go to collections, that'll affect your driver's license. So if you need to get on a payment plan with the clerk, go see them, they'll work with you, okay? All right, sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck, sir.
Thank you.
Thank you.
Chandler Allen was next.
All right.
Good morning, Your Honor.
Good morning, Mr. Catalinic. And you're here on Mr. Allen, correct?
Chandler Allen.
And he is present. That's 23 CF 2676.
Your Honor, we're going to be admitting to the allegations of the VOP, and we have a plea agreement signed.
Excellent.
If I may
Thank you.
approach.
Yes, thank
Your Honor,
you.
because for an adjudication of guilt, 90 days Okaloosa County Jail, revoke and terminate probation credit for time served.
Wonderful. Thank you so much. Yes.
The underlying charge, Judge, was a misdemeanor.
Is that misdemeanor reckless driving or?
Yes, Your Honor.
Okay,
2
great.
counts of reckless driving.
Thank you. And was there a previous adjudication of guilt or?
On the misdemeanor, I believe so.
Thank you. All right. Mr. Allen, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down if you'll state your name, please.
Chandler Allen.
Thank you, Mr. Allen. In case 23 CF 2676, it's alleged that you violated your probation. There is an affidavit that was filed on September 16th, 2025, and it has 3 allegations in it. Have you had a chance to talk to your lawyer about those allegations that you violated your probation? And
Yes.
any possible defenses?
No, ma'am. Yes, I talked to him.
Okay, thank you. Did you discuss this plea agreement with your lawyer?
Yes.
Did you read and sign the agreement?
Yes.
Is that your signature on the back?
Yes, ma'am.
Are you admitting the violations today freely and voluntarily?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes.
Do you understand you're giving up your right to have an evidentiary hearing?
Yes.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, if you have not already been adjudicated guilty of the underlying charges, you are now. And I find that you have violated your probation as alleged in the affidavit. And probation will be revoked and terminated. You are sentenced to 90 days in the Okaloosa County Jail on, I'm trying to remember if the counts were running concurrent or not.
It was consecutive, the probation was, Your Honor. It was, I'm almost positive it was for a full year.
That's correct, Your Honor.
Okay, so,
It was 6 and 6.
gotcha. Okay, so he's only on probation for one of them right now, or he's still in this? Or, no, I take that back. He's still in the first 6 months when this occurred.
Yes, Your Honor.
So, okay, on each of the underlying charges, It does look like there was a previous adjudication of guilt.
Yes, Your Honor.
Probation is revoked and terminated, and you are sentenced to 90 days in the Okaloosa County Jail, and are those concurrent?
Yes, Your Honor.
Okay, concurrent, with credit for time served, plus there will be a $100 VOP cost of prosecution fee, and I believe that is the only, let me check.
I don't think it's in the plea, Your Honor.
Sorry?
I think I left it out of the plea.
That's okay. So the court's required to impose that, so there's a $100 additional cost.
Okay.
No objection, Your Honor.
Thank you. I'm just writing it on here. Any other terms or conditions or anything I've missed?
Not that I can think of, Your Honor.
Okay, so sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. I don't know how much credit you have, but whatever credit you do have, you'll get, okay?
Yes, ma'am.
Good luck to you, sir.
Thank you.
Thank you.
Thank you.
See you later. Thank you, Your Honor. That's all I have. Yes, Your Honor.
All right, I see Mr. Nope's present. I'm not sure who all else is present that I need to take it.
Judge, I need a few minutes and wait and see if the state's got one there.
Okay. I see Mr. Harper. Do I have any other private attorneys present? Okay. And I have somebody in the Zoom waiting room. I'm not sure who that is. All right, to the person who is in the Zoom, well, just appeared in the Zoom hearing, could you state your name, please, and which case you're here on? You're on mute.
Michelle Gates from Marcus Gates.
That hearing was handled earlier this morning.
Yes, ma'am. Thank you.
Thank you. Do I have Cedric Hill present? Yes, come on up, Mr. Hill. All right, this is case 23 CF 600. And could you state your name for me, please?
Cedric Hill.
Thank you, sir. You're here on an order to appear for allegations that you violated your probation. And I see that you don't have an attorney. Would you like me to appoint one for you?
Yes.
I'm appointing the Office of the Public Defender.
Yes, Your Honor, that'd be me. Is there an offer for Mr. Hill to consider?
It's 90 days in the Okaloosa County Jail.
And let me just read the allegations so that, Mr. Hill, I believe you were, I saw you, what I think is your signature on the form, so I think you may have been informed, but I'm just going to go ahead and announce them so everybody's clear. So I'm not expecting you to say anything, I'm just making a record. So on October 6th, there was an affidavit of violation of probation filed. The three allegations are failing to make court costs. It was alleged that as of October 3rd, you owed $1,878. The next allegation is failure to complete first level DUI school. And the third one is failure to complete your community service. You were ordered to do 50 hours, and this is alleged that you hadn't completed those by October the 3rd, 2025. And Mr. Gates, I just want you to be aware of that.
Yes, Your Honor, I was just pulling up to see if you had the name of your statement.
I believe the same or similar allegations were before the court last January.
Yes, Your Honor.
And probation was extended
Yes, Your Honor.
for that reason, and we're back.
Yes, Your Honor. At this time, if we can earn denial.
Okay. And let's set the next court date, which will be December 16th at 9.
Yes, sir.
And sir, stay in touch with Mr. Gates. Make an appointment to see him prior to that court date, December 16th at 9. And let me make sure that we have a current indigency application on file. I do not see one, so you'll need to fill one out before you leave.
Okay.
Okay? And we should have the form, we'll provide it to you. So please fill that out, turn it in. Let Mr. Gates take a look at it before you leave court today, and then you'll take it down to the clerk's office on the first floor when you're done, okay? Before you leave the building.
To the first.
So fill it out here in court, have Mr. Gates take a look at it, make sure it's complete. Then you will take it down to the first floor to the clerk's office and hand it in.
Okay.
Okay, before you leave today. Thank you, sir. I'll see you on December 16th at 9.
Okay.
Judge,
Yes.
is it okay with taking the start as a miss out and not just?
Momentarily, not right now. Just 1 second. Do I have Grace Estrada present? Come on up, ma'am. Yes, ma'am, if you'll state your name, please.
Grace Estrada.
Thank you. You're here on an order to appear for allegations that you violated your probation, and let me just pull that up. My notes say that you don't have a lawyer. Would you like me to appoint one for you?
Yes, my last one was Rachel Farkas.
Wonderful. I'm appointing the Office of the Public Defender. Ms. Farkas is here. And Ms. Farkas, I'm just going to read the allegations.
If I could have a minute with the state attorney.
Sure.
I just spoke with the state about this case, and if I could have a minute just to let Ms. Estrada know what the state's offer is.
Sure.
We might be able to just wrap this up today.
Do you mind if I call another case while you do that? Okay. So we'll pass Ms. Estrada 24 CF 836. All right, do I have Robert Harris present? Robert Harris. This is 24 CF 1655. Good morning, sir. If you'll just state your name, please.
Robert Harris.
Thank you, Mr. Harris. I have you down as having no attorney. I know that you were here on October 21st. We continued the case till today to give you more time to pay off your costs. And I'm not sure if maybe I should get a report from Mr. Doobie, who's the probation officer present here, to see where we stand with that. And then if you'd like an attorney, I'll appoint one. So sorry, 24 CF 1655. The case was not on the docket, but I did continue the case till today when we were in court last time.
So what I'm seeing according to our records, Your Honor, is the total costs have been paid according to the clerk's site. There's still an outstanding balance for cost of supervision and a drug testing fee.
Okay. What about the community service?
Still showing that there's 24 hours remaining.
Okay. Sir, do you want me to appoint a lawyer for you at this time?
Yeah.
Okay, I'm appointing the Office of the Public Defender.
Commissioner, in my preference, I think we can get resolved if Mr. Harris can get the community service work done in the next cycle. I think because the supervision, probably probation, we want to waive, that would leave the drug testing fee. Is the state kind of inclined to do that?
No.
Well, my thing is, I paid off on my court fee, and then I went on a correct pay and paid by $400 or $389, and then everything supposed to come to like 12 or 11. I was asking to buy out the community service. I got a new probation officer like 3 times, so they could never appoint that. So when it got off into the thing, I tried to pay all of it off in one day. When I went to the DSC site to try to pay it off, he said I would pay it off. And I kept trying to ask my probation officer how much I needed to pay.
Okay.
He ain't never have no answer to me. He said, just go to court. So what is the balance?
Well, I'm looking,
Would the court be inclined to allow him to purchase that community service work out?
I was going to say, I'm looking at the probation order and it says may buy out.
Okay.
I mean, that was ordered back, I think it was Judge Ketchel who, yes, Judge Ketchel signed the probation order on October 17th, 2024. It was from a court date of October 14th, 2024. It does say that he can, sir, it says in your order that you can buy out your community service, but that would be at minimum wage. So,
And it sounds like we need the clerk to authorize that, is what probation's saying.
I can notate it on the minute sheet. But as far as what the balance is for what needs to pay off, and then it would just need to be provided so we can enter that in.
Yeah, because normally what probation does is we file a letter requesting that additional court cost to be open based on the community service hours we can bring to financials.
do you want to buy them out, sir?
Yeah, I want to know what I need to pay to just get off of it and don't become a court, come miss some work. I mean,
Yes, sir. And I know the state has already said she wouldn't decline, but if we can get all that paid by next court date, then maybe we can figure out another alternative if the state's not willing to work with us on that.
Okay, so correct me if I'm wrong, but the current minimum wage is $14 an hour, I think.
Correct, Your Honor.
Thank
I
you.
know it's going up, what, in
So it'd be $336 for the.
That's what I got.
community service hours.
$336 to pay off your community service and be done with that.
okay.
Now, I don't know what the balance is on the cost of supervision and drug test fee. I don't know what that is.
The cost of supervision currently is $480.
Say that one more time, I'm so sorry.
$480,
Okay. Currently. Okay.
and the drug testing fee balance is $30.
Okay.
So that's 4 plus 3, so that's 780.
And there'd be no objection to waiving COS, Your Honor.
All right. What about the drug test fee? Is that included or no?
That we
So-
cannot waive that.
Okay.
so 336 to 366 is what you have to pay.
366 total?
That's what it's, the court's going to clarify, but I think that's.
Yes, so it sounds like probation has graciously waived the $480 cost of supervision balance, so you don't have to pay that. Thank you to probation for doing that. That was, I mean, you might want to thank them.
Oh, thanks, but I thought I paid it. I mean, I don't know.
Okay, well,
We'll figure it out, Your Honor.
you still owe a $30 drug test fee, and then if you want to buy out the 24 hours of community service, instead of doing the actual hours, it's $336. So that's a total of $366, looks like.
All right. And if we can go to December 16th, and Mr. Harris will have that paid by then, I think.
Yeah.
Okay.
At that point, we could probably bring it in for a lender.
So where does he pay that, and how does he pay that?
I think the probation will send a memo to the clerk's office.
Yes, I'll have the assigned officer send a letter to the clerk's office to get that account open.
Okay.
The drug testing fee would still need to be paid.
All right,
Correct
okay.
pay.
Okay,
Correct pay?
Yeah,
$30.
the drug testing fee will, so we'll probably give it a couple days, but contact Officer Brown, and he'll be able to give you that final amount.
All right,
Once we get everything adjusted in the system.
okay,
And then
Okay.
pay the court costs, or community service work to the clerk's office.
all right.
so sir, I'm going to set you for December 16th at 9 o'clock. And that'll give you another month to try to get that taken care of, okay?
All right.
Thank you, sir.
Appreciate it.
Mr. Harris.
All right.
Ms. Farkas, are you ready on Ms. Estrada?
Your Honor, if I may, given that Ms. Estrada is interested in accepting the state's offer,
Okay.
I'm going to, as a friend of the court, suggest that Your Honor not appoint the public defender and save Ms. Estrada $150. So Mr. Sprouse has the plea agreement that he'll give to Ms. Estrada to sign.
Okay.
But I just suggest that our office not be appointed and save her a little bit of money.
Okay, so ma'am, I believe Mr. Sprouse may be writing up an agreement, is that right?
It's on its way. It's
Okay.
in the
So-
interwebs. It's just taking time to get here.
So whenever you get that agreement and after you've read it, if that's what you want to do, then we'll talk about that. But I'll just wait and give you a chance to get that and take a look at it, okay? And we'll call you back up. Okay? All right, I see Mr. Flowers is present. Mr. Flowers, do you want to go ahead and take your cases?
Thank you, Your Honor. I'm here, I'm aware of one case, and I apologize if I'm missing something.
I have 3 on
Well,
the
I'll-
docket.
I'll be prepared to take them.
Okay, and they're all down for an early plea or change of plea. We set them in October. I have Robert Bolton. Is that the one that you have?
No, Your Honor, and I don't know what, I apologize for that fact. I will tell you that I've discussed the matter with Ms. Basso. She tendered a suggested offer which my client has not accepted, and I apologize for that.
Okay.
But
So,
what I might suggest is we just set it for trial. I mean, he needs to make a decision, and we,
yes,
and I don't think in good faith I have a reason to ask for a continuance.
so,
So the next trial cycle might make the most sense for us, Your Honor, if
Think
it's
it-
okay with you.
of course. This is case number 25 CF 595. The defendant is not present. And on October 13th at pretrial, that's when we set the case for today for change of plea.
I may have been more confident than I should have been, Your Honor.
Okay, so let's set it for December the 8th,
Yes, Your Honor.
pretrial?
Thank you, Judge.
Sure. And that'll be at 9 o'clock?
Thank you.
Yes, and please have Mr. Bolton
He will
present.
be present, Your Honor.
Okay,
Zebekiah Bridwell,
yes.
I mean, is that in that file?
That is
Frankly,
25 CF 1099. I have that one down for a change of plea as well.
Judge, I'm going to ask that, we communicated with the state yesterday and haven't reached an agreement. We will. Having said that, I'm going to ask for pretrial December 8th on that case, Judge, that
Okay,
it may even be a plea to the court. It's a very unusual scenario. If it were a trial, it'd take 30 minutes.
okay. So I had this one set, we were here on October 13th. It was
Yes.
set for today for change of plea. So we will set the case for December 8th.
Your Honor, I do have a note from Ms.
Yes.
Bossa. This is, of course, Ms. Bossa's case. She's in actually trial right now in
Yep.
Crestview today. The note that I have, that we would leave the offer open to November 20th if we wanted to pass it Thursday, but after that, the offer would be revoked. Let me see, she sent it in an email to you, I believe.
And she did. I haven't been in the office today. I've been in Washington County, so I don't doubt that she did.
I don't see the offer here, but this is an email that I think you guys were talking yesterday.
And I don't doubt
Okay.
for one second that happened. I emailed her yesterday. Judge, I went straight to Walton County where I just left court and came straight here. I don't doubt that she has sent something to me, but I haven't had an opportunity to see it.
Okay.
Ms. Bossa plans to be here Thursday, so I'm sure we can pass it to.
I think I'm going to be with you.
I'm not setting the case on Thursday until I know there will be a plea on Thursday. So here's what I'll do. I'm going to set it for December the 8th at 9, that's pretrial.
Right.
Mr. Flowers, if you find out, if you could just give us 24 hours notice.
I can do that, Judge.
So I can set the case for Thursday morning, but I would need to know tomorrow.
I understand, Judge.
Sure, so that I can make sure that, I mean, he's not in custody, so.
No.
That transport from the jail is not an issue, but I just need notice so I can let the clerk know. But I'm happy to take his plea on Thursday, but I don't want to set it until I know there's actually a plea. So,
Very well.
yes, if you'd like to bring it in, just give us some
I'll
notice.
make every effort,
Tomorrow.
as will Ms. Basso, I know to do so.
Okay, but right now, we're setting the case for
Thank you.
December the 8th at 9.
Very well.
Okay, thank you. And then I have Mr. William Downey. That is 23 CF 2743. He's on the docket for today as well.
Judge,
for
here's what,
Status of records.
and your notes will reflect this. I know this court takes notes. He has requested records. The government shut down. He couldn't get them. I can't either because they're from the VA in the state of Texas and in the state of Mississippi. So I'm going to suggest he's made his best effort. I know he has. We have as well. And I know the state wants to see them. I do too. It has to do with the treatment he's received. The court will recall an extensive medical procedure, but there's also some other factors that he has received treatment for.
Okay.
Judge, my suggestion is December 8th, but with I wish we'd had the records too. I wish the government hadn't shut down.
Yeah, I
That's-
mean, me too, for that reason.
I know.
If nothing else, but yeah.
And Your Honor, you know everything I know with respect to that. We've made our efforts, as has Mr. Downey, because we've talked about his efforts that he's
Okay.
made.
State?
State's just waiting on the records.
Mr. Sprouse and I have talked about it. He's as frustrated as, frankly, we all are.
So
Would that be a
government's
fair statement?
back open now.
That's fair. That's a fair statement. So, as you recall, there is, the state's kind of pinholed into
Yeah.
the law and what we can offer short of mitigating factors and evidence of mitigation. So that's what we're waiting on.
And Judge, in fairness to the state, he was reluctant to make certain recommendations until he saw this because they might be or unfair. I think that was the comment that, and I'm not surprised he made it because it's the right thing to do. But that was the comment the state made.
So the government's back open.
Yes.
So can Mr. Downey go to the VA and try to get his records that way?
I will find transportation for him to get there.
Okay,
That's the best I can do, but I can do that.
okay. I think he may already be set for December the 8th. Let me double check. I think today was just a status on those records.
Yeah, that's all I can do.
I don't show that he's set.
Okay. Okay, he's not set for December 8th, just for today.
But he will be, is my
He is
understanding.
now, December the 8th, pretrial conference, 9 o'clock.
Thank
I
you.
know we've been held up on these records, but this case is coming on 2 years old.
Couldn't agree more, Your Honor, and I appreciate the court's indulgence, and I understand it as well.
Okay, so I need to know, I'm going to need to know details of his efforts between today versus December 8th.
Fair.
Trying to get the records. At some point, we're just going to have to
I understand, Judge.
just move forward. Because, you know, I think I've said every single court date since April last continuance, but I know that we've been hung up on these records, and I know they're critical,
I know.
that the state needs them, and it would make potentially a huge difference in the case. I get it.
That's my belief as well. Judge,
Okay.
I do believe that's all I have before this court.
Okay, I just need,
Thank
I'm
you.
going to be asking questions on December 8th of what concrete actions have been taken since today's date of November 18th.
I hope you won't have to ask those questions,
Okay.
frankly.
Me
And I
too.
know you do too.
Me
But-
too.
But
I'm
I
just-
understand, Judge.
Just one, I'm going to be, you know, the government's back open. He needs to go to the VA and start making noise there and get his records,
Very well.
if possible.
I
Thank you.
understand. Thank you.
Thank you. All right. Do I have? I think they're all in custody, actually. All right. So is Mr. Nopes ready or no? All right, Mr. Harper, whenever you're ready, come on up.
Yes, ma'am.
I can take him out of custody, Judge.
Go ahead.
If I may. It'd be Roderick Alston.
Yes, 24 CF 715.
He is present in a wheelchair.
All right,
Judge, this would be a plea.
okay.
He is present and approaching before the court on 24 CF 715. He's going to be entering a plea of no contest. This will be a plea to counts 2, 3, and 4. Count 1 would be dismissed. He'd be adjudicated guilty, be sentenced to credit for time served to run concurrent, be assessed $615 in court costs, $150 cost of defense. He is asking for 18 months to pay the costs. Judge, this is a stipulated downward departure pursuant to a negotiated plea. If I may approach.
Yes. Thank you very much.
And if your Honor needs further explanation regarding the plea, we can approach.
I actually do, because I need to know, I have a question about signing the score sheet.
Yes.
And if you could help me out with that. Thank you for that. All right, Mr. Alston, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down if you'll state your name, please.
Roderick Austin.
Thank you. In case 24 CF 715, your original charges are possession of a firearm or ammunition by a convicted felon. That's a second-degree felony, and it carries a maximum of 15 years state prison. I believe there's a minimum mandatory of 3 years, if I'm not mistaken. Then count 2 is possession of a controlled substance. That's a third-degree felony. Maximum penalty is 5 years state prison. Count 3 is possession of drug paraphernalia. That's a first-degree misdemeanor, and it carries a maximum of up to a year in jail. And count 4 is resisting arrest without violence, also a first-degree misdemeanor, also has a maximum penalty of up to a year in jail. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses?
Yes, ma'am.
Have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature at the top of the back page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I have a score sheet that shows 80.6 total sentence points. Any objections or corrections? Is there any exculpatory DNA?
No, Your Honor.
No, it's not.
I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, ma'am.
Do you understand that an adjudication of guilt on the possession of a controlled substance charge could result in your driver's license being suspended?
Yes, ma'am.
Looks like you're pleading to counts 2, 3, and 4. How do you plead to those counts?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement on count 1?
Your Honor, the state will be null crossing count 1 in exchange for a plea to counts, the additional counts.
All right, thank you. On counts 2, 3, and 4, in accordance with your plea agreement, there is an adjudication of guilt, and on each of those charges, you are sentenced to time served, concurrent, and the court costs and fees are $615 in court costs, $150 cost of defense, that includes the application fee, and you have 18 months from now to pay those costs and fees before those go to collections. Did I cover everything, Mr. Harper?
Yes,
All
ma'am.
right.
Other than it's a stipulated count.
It is a stipulated downward departure based on the state's and the defendant's legitimate, uncoerced plea bargain. Because, sir, you do score prison. You're aware of that, right?
Yes, ma'am.
Okay. So you do have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck, sir. Thank you.
All right, thank you.
Emily Hall is up next.
Okay, this is case 22, CF 1756, Emily Hall, and she is present. We're here on allegations of a violation of probation. The affidavit was filed on December 26, 2024.
Second. Judge, this is Emily Hall before the court on 22 CF 1756. At this time, she's going to withdraw her previously entered plea and admit the violation of probation, be adjudication of guilt. She'll be sentenced to 9 months in the Okaloosa County Jail, credit for all time served to run concurrent, revoke and terminate her prior supervision. There's a $150 cost of defense, $150 cost of defense, $100 cost of VOP, and she's asking for 18 months to pay these costs. If I may approach, Judge.
Yes. Thank you. Thank you so much. All right, ma'am, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down. If you'll just state your name, please.
Emily Hall.
Thank you. And let me pull up your case. In case 22 CF 1756, it's alleged that you violated your probation. It looks like the affidavit was filed on December 26, 2024, and it contains 6 allegations. Have you had a chance to discuss those allegations with your lawyer?
Yes, ma'am.
All right. Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes.
Is that your signature on the back?
Yes, ma'am.
Do you understand you're giving up your right to have an evidentiary hearing?
Yes.
Are you admitting the allegations that you violated your probation freely and voluntarily today?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on the agreement?
No.
Are you satisfied with the services of your lawyer?
Yes.
I have a score sheet that shows 33 total sentence points. Any objections or corrections?
No, Your Honor.
All right, ma'am, I accept your admission. And I find it was freely and voluntarily entered. In accordance with your agreement, the court finds that you are guilty of violating your probation. I believe there's already an adjudication of guilt on the underlying charges. On each of those charges, you will be sentenced to 9 months in the Okaloosa County Jail with credit for time served. Those will run concurrent. Your probation is revoked and terminated, and the following additional costs and fees are imposed. $150 cost of defense, that includes the application fee of $50, and a $100 VOP cost of prosecution fee. And once you get out, you'll have 18 months to pay all of your outstanding costs and fees before they go to collections. And good luck to you, ma'am. You have 30 days to appeal. If you cannot afford a lawyer, I will appoint one for you. Thank you.
Thank you.
Matthew Henry's up next.
Judge, this will be a plea. He's before the court on 24 CF 1959, if I just have a moment.
Sure.
Court, if we can address this one first.
Okay.
This is 24 CF 1959. He's before the court on a violation of probation. He's going to admit the violation of probation at this time, be adjudicated guilty, be sentenced to credit for time served, to run concurrent, revoke and terminate his prior supervision, be assessed a $150 cost of defense, $100 cost of the VOP, and he's asking for 18 months to pay those costs. This is a plea to just misdemeanor, so there's no score sheet or approach.
Yes. Thank you. So the amended affidavit that was filed on October 10th includes 11 allegations, including some new law offenses.
Your Honor?
Yes.
May we approach?
Yes. All right, in case 24, CF 1959, I am referring to the amended affidavit of violation of probation that was filed on October the 10th, and it does contain 11 allegations. Mr. Harper, would you like me to read what they all are?
I don't believe that's necessary, Judge.
Okay. All right, Mr. Henry, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down.
Thank you, Your
Could you please state your name?
Honor. Matthew Henry.
Thank you. In 24 CF 1959, you just heard me read out that there are
Yes, ma'am.
11 allegations that you violated your probation on
Yes,
the
Your Honor.
amended affidavit filed October 10th. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, Your Honor.
All right. Have you discussed this plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the agreement?
Yes, Your Honor.
Is that your signature on the back?
Yes, Your Honor.
Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes, Your Honor.
Is anyone forcing you or threatening you to make you admit the allegations?
No, Your Honor.
Has anyone promised you anything other than matters you may have discussed with?
No, Your Honor.
Okay. Are you satisfied with the services of your lawyer?
Yes, Your Honor.
Are you admitting the 11 allegations in your, in the affidavit that was filed on October 10th?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily entered. I believe you were already adjudicated guilty of the underlying charges, which are 5 counts of possession of drug paraphernalia. The court finds that you are guilty of violating your probation based on your admission. And in accordance with your agreement, probation is revoked and terminated. And you are sentenced on each of the counts to time served, concurrent, and court costs are, these are in addition to any previously imposed costs and fees. $100 cost of prosecution, VOP fee, and $150 cost of defense. That includes the $50 application fee. You will have 18 months after you get out to take care of all of those costs and fees before they go to collections. Did I leave out anything?
No, Your Honor.
All right. So, sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. That takes care of 24 CF 1959. And I know there is a new law, 25 CF 2062.
And Your Honor, it might be more efficient if we just send a stipulated order as to that amount, and I can take care of that probably within an hour. And I'll just speak with the state about that, and I think we can address that off the record.
Okay. If you can give me a paper order in court today, I'll be able to sign it. If it's electronic, I don't know if I'll see it before close of business today, because I'm going to be in court literally all day and probably longer than
See what I
that.
can do about that immediately.
Yeah.
I don't have
So-
a blank order, but I'll figure it out.
Okay, I have some if you want to have a fill in the blank one. Just, if it's stipulated, please make sure it's clear on that order that the state stipulates. Sure. All right.
Your Honor, forgive me, could we recall Ms. Grace Estrada?
Yes, just one second. Thank you, Mr. Henry. All right. Okay, just making sure we were concluded on Mr. Henry for now. All right, so Ms. Estrada, and I have one more of Mr. Harper's on the docket, so we'll have to address that before Mr. Harper leaves. Mr. Harper, don't leave before I see you on another case that's on the docket. All right, this is Ms. Grace Estrada, 24 CF 836, and we're recalling Ms. Estrada.
Judge, may I approach with the agreement and the score sheet?
Yes. Thank you. Thank you so much.
I informed Ms. Estrada that I cannot answer her legal questions because I'm the state. I did make a change, as you see, that Ms. Estrada initialed next to. She would like the outstanding costs to go to collections.
Okay, thank you. All right, Ms. Estrada, let me pull up your case. I had it up a minute ago, but let me pull it up again. Okay, ma'am, I'm going to swear you in, so if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down, and if you'll just tell me your name.
Grace Estrada.
Thank you. And it's alleged that you violated your probation. There was an affidavit filed on November the 5th, 2025. There was only one allegation in there, and that's that you failed to make your court cost payments, and that as of November 4th, you owed a balance of $772. And so based on that, that's when I issued an order for you to appear today. I did not issue an arrest warrant. Have you had a chance to review the allegation that you violated? Okay.
Yes, ma'am.
All right, and I've been handed a plea and sentencing agreement. And ma'am, did you read this document?
Yes, I did.
All right, is that your signature on the back page?
Yes, ma'am.
All right. And do you understand that you have the right to have a lawyer represent you, and if you can't afford one, I'll appoint one?
Yes.
Okay. And are you wishing to proceed right now to enter this admission without a lawyer?
Yes, ma'am.
Okay. Ordinarily, if we were here on a more serious matter, I would have a lot more questions for you on that, but in light of the agreement, I'm going to proceed without going through that long process. Ma'am, are you admitting the allegation that you violated your probation by failing to make the court cost payments?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, the court finds that there is, in fact, a violation of probation. I believe you were previously adjudicated guilty of the charge. Yes, you were. Probation is revoked and terminated in accordance with your agreement. You're sentenced to time served, and all of your outstanding costs are going to go to collections. For today, there's an additional $100 cost of prosecution fee. Isn't that correct, Mr. Sprouse?
That is correct.
Yes. I'll just write that on here. So whatever you owe for court costs will go to collections. And ma'am, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, ma'am.
Thank you.
Thank you.
See you later.
Yes, ma'am, thank you. All right, and
Your Honor, if I can recall my last case.
yes,
It's Tiara Hawley, 25 CF 1324.
yes.
The court may recall that we've had a number of issues trying to ensure that she had notice of today's.
Oh, fantastic. Hi, Miss Holly, I'm Judge Clark. Can you just state your name?
Tiara Holly.
Wonderful, thank you.
If I may have a moment, Judge.
Sure.
Judge, Ms. Hawley is present. She's given me her newest phone number, and I will use that to facilitate an appointment with her. And if I can move this to the December the 8th, there's some issues that we need to work out, both between her case and her co-defendant's case. And so I just need some additional time to do that, Judge. So I would ask, continue this to December the 8th.
I would also ask, forgive me for interrupting, for the defendant's address, because
Yes.
we tried to get her served, or the public defender's office tried to get her served, but we didn't have an address for her.
Okay, is there a form up there, Mr. Harper, for her to fill out her address and everything? And let me see if there's an indigency form. Oh, there is, okay. Ma'am, I see an address on your form, and it says 936 Barrow Street. Is that accurate?
Yes.
Okay, and if you wouldn't mind filling out that form with your current phone number and email address, go ahead and just write that address on there anyway so that we have confirmation. And then that'll be for the clerk of court to make sure that they have the most up-to-date contact information for you. And we will set Ms. Hawley for pretrial conference. And how does the December date sound? Or Mr. Harper, do you?
December 8th is fine, Judge.
Okay. December 8th, 9 o'clock, pretrial conference. So, ma'am, your next court date's December 8th. There should be something to write that down.
I wrote it, Judge.
Excellent. And you need to make an appointment to talk to Mr. Harper before then.
Okay.
Okay? So, Mr. Harper, did you give her your card?
Yes, ma'am.
Okay.
She's got it.
So, ma'am, I am ordering you to make an appointment to talk to him prior to December 8th, okay?
Oh, thank you.
Thank you. All right.
Thank you, Judge. I believe that's all I
Sure.
have. I'm finishing up that order, and I'll have that shortly.
Thank you very much. I see Mr. Nopes. Is Mr. Nopes still present? Okay. He was here, and we will recall Mr. Nopes momentarily. So, Mr. Medina, Ms. Farkas, Mr. Gates,
I have a couple out of custody.
let's call people who are out of custody and try to,
If we could call Matthew Elliott,
sure.
he's present, 24 CF 1969. He's present and approaching.
Yes, okay. All right.
Your Honor, Mr. Elliott, we're here for a status on a third competency evaluation.
Yes,
The court appointed Dr. Salinas.
yes.
Mr. Elliott had an appointment with Dr. Salinas last week, I believe it was last week, on November 11th. However, Mr. Elliott got very sick and wasn't able to attend. He's already been rescheduled for December 23rd. I've let Ms. Basso know, and I wanted to make sure Mr. Elliott was here in court so that Your Honor would know he is making every attempt to attend that appointment. Just
Okay.
was unfortunate timing, getting
Okay.
sick last week. So he's already been rescheduled for December 23rd, and we've already let him know the date and time and location and everything.
Okay, so I see that we're scheduled for pretrial on December the 8th.
I don't know if we should just skip that court date and put it on the February pretrial date, given that he won't have done the evaluation by then.
Okay.
I would certainly be waiving his appearance on December 8th. I'm not sure if Your Honor would feel comfortable with that.
Well, what I want to do is make sure that we stay on track with the appointment.
Yes.
So I could,
Maybe a miscellaneous date in January?
we could do that. I think that would be January 13th. So right now I will cancel the December 8th pretrial, and we will set the case for January 13th, 2026, 9 o'clock for competency status.
All right.
So, Mr. Elliott, it is critical that you keep that appointment that you have with Dr. Salinas for December 23rd. Do you understand?
Yes, ma'am.
Okay, and your next court date is January 13th at 9. So, Ms. Farkas, if that appointment is not kept, unless that would be through, unless the doctor cancels that appointment or there's some overwhelming emergency,
Yes, Your
then
Honor.
the court is going to look at its options to
Yes.
ensure that an evaluation takes place.
Absolutely.
Okay.
It is in Mr. Elliott's best interest as well that we get that appointment handled.
It is,
So,
because the options would be put him in jail and have him evaluated there. And I don't
Yes.
want to do that.
Certainly want to avoid that.
Okay.
Thank you so much, Ann.
December 23rd is your appointment with the doctor. You need to go to it. And then you need to be in court on January 13th at 9. Okay?
Yes.
Thank you.
Thank you.
Your Honor, may I have a question with this order?
Yes.
Judge, I spoke with the state legal review. They have no objection.
Okay, so I've been handed an order on Mr. Henry James in 25 CF 2062, and it's a stipulated order to reduce bond, and the state and the defense appear to have agreed. Let me just make sure from the state stipulated, correct?
Yes, Your Honor.
I mean, I know it is because it's written on here, but I'm just getting it on the record. I'm signing the order, so Mr. Henry, or Mr. James will have a bond.
And he does have, just so the court is aware of the full context, he does have those criminal traffic offenses that are outstanding, and I believe his bond is revoked on that. However, he has court with me tomorrow, and we intend to enter a plea to resolve those, so he should be out tomorrow.
Okay. Well, this takes care of his bond on the pending felony. Thank you.
Thank you, Judge, that's all I have.
Okay, thank you. All right, Mr. Nopes, you ready? Okay.
Judge, I believe the first case I have is Chad Cart.
Okay, and that is 25 CF 801. We're here on a motion to recall Capias.
We're actually, Judge, we're gonna,
It's already been served, it looks like.
oh, well,
Well, I mean, he's in jail,
we're
so.
in a plea.
Oh, okay,
Yeah, we're gonna dispose of it.
all right. Okay, the defendant is present.
Sign right there, please. May I approach, Your Honor?
Yes, thank you. Thank you very much. All right. All right, sir, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. If you'll state your name, please.
Chad Michael Cart.
Thank you. In case 25 CF 801, you're charged with one count of keeping a public nuisance structure for drug activity. That's a third-degree felony. Carries a maximum of up to 5 years state prison. And one count of possession of drug paraphernalia which is a first-degree misdemeanor. It carries up to a year in jail. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, I have.
All right, have you discussed this plea agreement with your lawyer?
Yes, I have.
Have you read and signed the agreement?
Yes, I have.
Is that your signature on the back page?
Yes, it is.
Do you understand the rights that you give up when you enter a plea?
Yes, I do.
You understand you're giving up your right to go to trial?
Yes, I do.
Is anyone forcing you or threatening you to make you enter a plea?
No.
Has anybody promised you anything other than what's showing on the agreement?
No, no.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, no.
I have a score sheet that shows 9 total sentence points. Any objections or corrections?
No, ma'am.
I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, I do.
How do you plead to counts 1 and 2?
Guilty.
All right, I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there is an adjudication of guilt on both counts. On count 1, you'll be placed on probation for 3 years. There are some special terms and conditions. You'll have to have a substance abuse evaluation and any recommended treatment. And you'll have to complete 100 hours of community service work. You must maintain gainful employment or complete 2 job applications per week. The court costs are, this is $515 plus $150. That's the court-appointed legal assistance fee. It includes the $50 application fee. And as to count 2, you're sentenced to time served. Did I cover all the terms and conditions?
Yes, ma'am.
All right. So, sir, is this the only thing holding you in jail, this case?
Yes.
Okay, then you should get out today. You need to see Officer Doobie. He is the probation officer in the courtroom, sitting right there on the front row. See him before you leave the courtroom. Then, if you get out before 4 o'clock today, you need to go straight to probation today. And if it's after 4 o'clock today, then you need to be there first thing in the morning before 9 o'clock.
Okay.
All right? Good luck to you. You have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one. Thank you, sir.
And so the question on the previous has been withdrawn or served?
I think it's been served, but if not, it's withdrawn.
So, right. I think it has been served, Judge.
I think that's why he's in jail.
Will you take, I guess, dismiss the case with you?
Yeah, the state's not gonna take any action on the failure to appear, Your Honor.
Okay, so if the habeas has not already been served, I suspect it has.
I'll just verify the sheriff's office or anything.
Okay, it would be withdrawn if it's not served.
So, Judge, the next case I have is Latasha Coleman, 24 CF 1104, 25 CF 0915.
And she is
Judge,
present.
I'd like to bring this back. I know if I don't want to continue it a full cycle. We're still having an issue that, I guess, this is one of the cases involved in the FDLE issue or case, which I believe is the 24 CF 1104. And the state wants me to bring them back my hard drive terabyte tomorrow.
Okay.
And then I'm gonna make arrangements to get it Friday morning, because the newer case, the 25 CF 915 case, is the one that we still have zero basic, a little bit of information, but not enough to understand the facts of the case.
Okay.
And so I'm gonna bring that down tomorrow. I've got to be here at court. I'm gonna go by and leave it with the state attorney's office, and then I'll come back Friday morning and pick it up.
Okay.
But I'd like to, I know next week is Thanksgiving, so there's probably not a day available to status it.
There might be.
Okay?
So if I have pretrial detentions, and right now I have no idea,
Sure.
but if I do, I'll be in court on Wednesday, the
Okay.
26th. And I already told, I believe it was Mr. Durrell, but I cannot remember, that if I have pretrial detentions, he was going to let me know on Monday if he needs to bring a client of his in
Okay.
on Wednesday. If so, it would be at noon. So what you're going to have to do is, on Monday, reach out to my office, see if I have pretrial detentions. Hopefully I'll know something by then, because if I don't have any, then I will not be in court on Wednesday.
Or I could probably just check the clerk's website, docket, right? I'm
you know-
being a bit sarcastic, Judge.
Well, no, I mean, and the reason that might not work is because it's like a day-to-day thing if we find out about the pretrial detentions, like a last-minute thing. So, you know, they may not have even received the paperwork yet. We may know before the clerk's office.
I'll email
But
Ms. Bailey in your office.
we would need no less than 24 hours notice and probably a little more to transport Ms. Coleman. So that, I really need to know on Monday.
I'll email Ms. Bailey on Monday morning, first thing, and then.
Yeah, maybe, yeah. She may not know that early, but if I have pretrial detentions, then I'm happy to set Ms. Coleman for noon on Wednesday, the 26th. But if I don't have any, I'm not going to be in court at all. So the problem is it's just unknown right now.
Well, actually, what's the date after? Because that made it Monday morning, I just looked at something I've got
Oh,
on my
okay.
docket in Walton County at 8:30.
Okay, so
So-
let me see. We may go into the pretrial in December, which is, I believe, going to be the 10th,
The
December
10th?
10th.
Okay. Judge, she thinks she's on the docket for the 10th.
I believe so.
For other cases.
Okay, so Judge, let's just take the 10th, because it's going to
Okay.
be dicey for me on that Wednesday.
Well,
I'm on that Monday
and
morning.
it's, you know, usually I do have pretrial detentions, so I'm in court, but on rare occasions, there aren't any.
Sure.
And I usually don't know until the day before. So, you know, there's a chance we may not have court next week. But let's just leave Ms. Coleman's cases set for pretrial conference on December the 10th. I think she's already set on those, for both cases on that day anyway.
Very good, thank you, Judge.
Thank you, thank you. Okay, and Mr. News, I see another case on the docket.
Yes, sir. Yes, ma'am.
Ms. Henson, Pamela Henson,
Pamela
23 CF 818.
Right.
Ms. Henson, are you present? Oh, great, come on up.
So Judge, this was just set today for status.
Yes, and earlier today, the mental health forensic specialist for Okaloosa County was here. She was here on an earlier case, so it's my understanding she is capable of providing the services.
Okay.
I mean, do you have any other updates or anything different than that?
I just asked my client, I don't know, Judge, is there a contact
Yes.
that she needs to?
Nicole Johnson,
Right.
and let me make a note of that. And let me find the contact information because I know which case.
Mr. Knopf?
Yeah, I do have an email.
Okay, the phone number is 689-7897.
7897.
7897. I'm looking at her letterhead in a different case that we handled earlier today. It's Nicole Johnson. She is the forensic mental health specialist, recently retained. So that's who needs to be contacted to do the services.
Judge, I'm also giving Ms. Henson, in addition to the phone number, I'm giving her
Thank you.
Ms. Johnson's email address as well.
Okay, so ma'am, you need to reach out to Ms. Johnson. You're going to be meeting with her so she can provide the services that I ordered quite some time ago, that because of the previous mental health specialist leaving her position, that's why this has, a new one had to be hired. So that's why there's been a delay.
Yeah, I understand.
So if you'll reach out to Ms. Johnson.
Immediately.
Thank you. Thank you. Let's set another court date.
16th of December.
Oh, I don't know what she's about to give it to us.
All right, Ms. Henson's case is 23 CF 818. And why don't we set you want the December date, which is December 16th, I believe.
Yes, ma'am, 16th.
Yes, December 16th at 9, Mr. Noops and Ms. Henson, for status on the restoration.
Very good, thank you, Your Honor.
Thank you.
Sure, thank you, ma'am.
I believe that's all I got, Your Honor.
I think so too. Thank you,
Thank you.
Mr. Nopes, very much. Okay, I see Mr. Gates. I see also there are several people in the courtroom. I'm not sure if any of them have a case or if they're here for,
Much as I'd love to go, but my inmates aren't even upstairs, so.
okay, whose inmates are upstairs?
Ms. Farkas.
Well, everyone else, okay. Are you ready, Ms. Farkas?
We have two no attorneys if she's not ready.
Let's bring,
I have a couple plea agreements that I'm still working out.
let me bring the people with no attorneys then.
Jordan Huntley.
Okay. Mr. Gates, I suspect you were about to be appointed. I believe you, Mr. Hunt.
One would be mine. I'm already appointed to the governor.
Oh, you are?
Yes,
Okay.
Your Honor.
And I apologize, Your Honor, there were just a couple last minute things that we were trying to take care of. I would probably be able to take the majority of my in custody clients, and we could just come back to the ones that.
All right, this is Jordan Hunt and case number 25 CF 921, and he should be out momentarily.
Your Honor, Travis Gates on behalf of Mr. Jordan Hunt for the court, the violation of probation.
All right, and he is present. And
Yes,
Mr.
Your Honor,
Gates?
this time we'll enter a denial on the VOP. He does have a new law violation set for Thursday. Does the state have an idea on resolution?
The state's in the process of coming up with an offer. I just need to speak with another victim.
If we can leave him for Thursday, we might have a resolution. I'm sure Mr. Hunt would like to do that if we can.
Okay, and my paperwork shows that Mr. Hunt has no attorney, so if you haven't been appointed, I'm appointing you.
Yes, Your Honor.
Okay, so as to this particular case, 25 CF 921, violation of probation, I know the new law case, 25 CF 2081, is set for Thursday, November 20th for arraignment, but what do you want to set this?
For Madam Clerk, I think if we just do this as a status, that way they can enter it into the system for Thursday. And then if we resolve it, it'll cover both cases.
So we'll set this case for the afternoon of November 20th?
Yes, Your Honor.
Okay. Okay. All right, sir. I'll see you in a couple of days, okay? Thank you. November 20th at 1:30 to track with the new law. Good morning, sir. I'm Judge Clark. Can you tell me your name?
Michael Edenfield.
Thank you. You're here in case 24 CF 2434, and you're here on allegations that you violated your probation. And Ms. Farkas, I believe you're already appointed on Mr. Edenfield's new case. Sir, in this particular case, I show that you don't have an attorney. Would you like me to appoint one?
Yes, ma'am.
I'm appointing the Office of the Public Defender.
Thank you, Your Honor. We'll have Mr. Enfield enter a denial today, and if we could continue this case to track with his newer case.
That new case, 25 CF 1849, is scheduled for pretrial conference on December the 10th. So we'll set this case, 24 CF 2434, also on December 10th at 9 o'clock, so they can track together. Thank you.
Your Honor, I've let Deputy Torres know of the people, the in-custody clients I have who I am ready for.
Okay.
So we can take those ones, and then I'll run to the printing for some of the agreements.
Thank you. I do see people in the gallery, and I'm not sure if any of y'all have a case or if you're here for someone else. Does anybody have a case? Come on up, sir. Let's see if we can go ahead and.
Your Honor, this is Mr. Cusimano.
Oh, yes, okay.
Ms. Gaynor and I are attempting to get in contact with the alleged victim in the case so that we could address a condition of the bond. So I'd ask that we pass his case for now. I'm going to see if my assistant is able to get in contact with her. We're just trying to see if the state can stipulate to a no violent contact.
Okay,
So I'm asking him to just be patient for a few minutes.
We will recall Mr. Cusimano, and
Thank you.
he's not on the docket because I guess we just set this recently, like a week ago. 25 CF 2043 is Mr. Cusimano's case. All right, we'll call you back up whenever Ms. Farkas is ready, okay?
Thank you.
This is Jordan Couch with Rachel Partners.
Okay.
Mr. Couch, you can come.
All right, Mr. Couch is present, and I'm going to read out the case numbers. 24 CF 1688, 24 CF 1690, 24 CF 1828, 24 CF 1829, 24 CF 1837, 24 CF 1885, 24 CF 2160, 24 CF 2161, 24 CF 2859, 24 CF 2860, 25 CF 77, those are the violation of probation cases. Now, I know there's also a new law case, 25 CF 1975, that was, it was set for arraignment on Thursday, November 13th. I don't remember if we did an arraignment or if it's arraignment today.
Yes, Your Honor, I entered a plea of not guilty
Okay.
on his behalf. I can re-enter it today just to be sure. And then we kind of continued everything to today so
Okay.
that everything would be tracking.
Okay, and there is a second amended affidavit of violation of probation filed on October 7th. It has 16 allegations.
Your Honor, today, Mr. Couch will enter a denial to all of the VOP allegations in each of the cases.
Okay.
I don't, at least the last I spoke with the state attorney, I don't believe there's an offer yet at this time.
Okay,
That is correct, there is no offer right now.
okay. Let me check and see. I believe the new case is probably scheduled for February, but let me check. Actually, it's set for December the 8th, so we need to move that to the 10th.
Yes, Your Honor.
Okay, and you want to set all of the VOP cases that day as well?
Yes, please. Just
Okay.
keep everything on the same schedule.
Okay, so all cases are December 10th at 9. That includes the new law case, 25 CF 1975, which is currently set for December the 8th, but it's going to be December the 10th. We'll just move it.
Thank you, Your Honor.
Sure. All right. Thank you, Mr. Couch. I'm sure Ms. Farkas will be in touch with you.
Yes, Your Honor, and Mr. Couch is not being housed here in Okaloosa County.
That's right.
So we'll have to make sure that we, just to let the court know that we will either file an order to transport him, or if the case is going to be continued, we'll make sure to do that ahead of time, so there isn't a confusion with his transport.
I will need the transport order well in advance. Okay, so, you know, I would say at least a week in advance.
Christopher Cluster is up next.
Okay, thank you.
Yeah, thanks, Mr. Couch.
Thank you.
This is Christopher Cluster, 2024 CF 2759.
Yes.
We were having Mr. Cluster evaluated for mental health court and the 90-day program. Ms. Myers did the initial evaluation for the 90-day program. I need to speak with Ms. Thornton about mental health court to see if that's still an option. I believe that the state is amenable to that if Mr. Cluster would like to avail himself. So if we could have a continuance, one more continuance. I know that she met with him and spoke with him, but I need to talk to him about what that would entail.
Okay.
And I believe she just met with him last week, so.
That would be December 16th at 9 o'clock. Thank you, sir.
Jarrett Dawson is up next. Mr. Dawson?
Okay, Mr. Dawson has 4 cases, 24 CF 2224, 25 CF 767, 25 CF 768, and 25 CF 769, and we're here for a status on Phoenix House, and the fact that you're still here tells me there's a problem.
Yes, so, Your Honor, I actually saw from the first appearance paperwork this morning that Mr. Dawson was just served on a warrant from last year on a petty theft, which essentially restarts the clock on his transfer to Phoenix House. I have no idea what's going on with that case. It literally went through first appearance this morning, and he didn't even get to appear because he was already here for court. So I need to speak with the state about that case to see if we can resolve it ASAP, because he would really like to get to Phoenix House. I would really like him to be able to get to Phoenix House. So unfortunately, I think we need to set this for another status, so that in the meantime, I can figure out what's going on with this new misdemeanor.
Okay.
Oh, it's a felony petty theft. Okay, I guess it's a felony petty theft, so it might come before your honor at some point anyway.
I'm sure it will, at that, if it's a felony.
Don't say it.
Don't. Your Honor, if we could have a fairly short court date, if we could put it, I guess no later than a December miscellaneous date, because
Yeah,
I think that we'll be able to resolve that, the new case.
Yeah, since first appearance was just this morning, I have no idea when the arraignment date will be.
Right.
But I can set, Mr. Dawson, I can set you on December the 16th at 9.
That'd be great.
So December 16th, 9 o'clock, and it'll be status of Phoenix House again? Or
And plea, I
Okay.
suppose. So I was relayed a few facts of the case from the defense. I think we're gonna be able to work it out. We'll just add like a term to the agreement, but we have to wait for the paperwork and stuff like that.
Okay.
I also don't have the paperwork, so I want to make sure I can advise Mr. Dawson properly.
But the offer's gonna stay the same, like, there's nothing gonna change, I'm not gonna renege on the Phoenix House or anything like that.
Okay. All right. So it sounds like it'll be resolved on December 16th. And,
Yes, I was just explaining to Mr. Dawson that the new case doesn't violate his probation because it occurred
it was prior.
prior to you
Yeah.
starting probation, so
Yeah.
don't worry about that. So we'll
So-
sort it out.
So we'll see you on December 16th, and we'll hopefully get everything sorted out then.
I know. This is Robert Eskold, the third, 25 CF 322. This is the first VOP date, the first time the VOP is up. I
Okay.
don't know if there's an offer from the state in this case.
Yes. So the offer from the state is an adjudication of guilt, 120 days of Okaloosa County Jail, and $100 cost of probation, cost of prosecution, rather.
Your Honor, Mr. Eskold is informing me that he would like to avail himself of that offer. If we could pass him for now, and I'll write up the plea agreement.
Absolutely.
I apologize.
Absolutely. So they're going to put it in writing, and then Ms. Farkas will bring you back out,
Okay.
and so you can read it and everything, okay?
Okay, thank you.
Thank you so much. I apologize, Your Honor.
Jabari Fountain is up next.
Okay, this is 2013 CF 1050, and Mr. Fountain is present. All right.
Yes, Your
Good
Honor.
morning.
This is Jabari Fountain. This is a case with Ms. Basso. There is a recommendation from probation to modify the terms of his probation. It would allow him to be released from OCJ. Ms. Basso is in trial today, so I'm wondering if we can put this case on.
Thursday?
Yes, that would be great. If we could put it on Thursday, that would give Ms. Basso time to review probation's recommendation, and then if we can get Mr. Fountain out of jail, that would be great.
Okay, so I have, let me ask Mr. Gates. Mr. Gates, don't you still have a hearing Thursday morning?
I do, Your Honor, but I don't think it's gonna take very long.
Okay, well, I just wanted to make sure I was,
Yes, Your Honor,
I'll still be here.
If we'll get to the court, I anticipate withdrawing at least 2 of those paragraphs on that motion. And I think the state's gonna concede the part of the witnesses testifying about the video.
That's,
But outside that, it shouldn't be more than maybe 5 minutes.
that's fine. I just was trying to see how my morning looked to set Mr. Fountain for the morning.
Yes, Your Honor.
Okay, sounds like we're good for 9 o'clock, and we'll take Mr. Fountain as soon as your hearing's done, or
Great, thank you.
maybe before.
Yes,
So
Your Honor.
November 20th at 9 o'clock, we will schedule Mr. Fountain. So, sir, I'll see you in 2 days.
Megan Dotson is up next.
No problem. I'll see you later. No, this is Megan Dotson, 25 CF 1338.
All right, and she is present.
Your Honor, this case was put on for status today. At the last court date, Ms. Dotson indicated that she did not wish me to work on her case any further and she was going to hire a private attorney.
Yes.
I don't have any information as to that. I don't know if that is still accurate. I do know that the state's offer in the case, we had written up a plea agreement. I do know that that offer is still valid. I just don't, if she's hiring a private attorney, I don't want to.
No, ma'am, I'm on
She's, okay.
Okay.
And I'd
so-
like to take it.
Okay, so.
Okay, so I'm going to have Ms. Dotson sign the plea agreement, make sure she remembers the terms.
I
Okay,
just want to make sure, I'm pretty sure there's a misdemeanor.
what?
Oh, yes, I'm sorry. So she's currently incarcerated because there was a new violation of injunction.
Which is a crime, which is a misdemeanor, so it
Yes.
wouldn't be wrapped up into the felony, so that would still be outstanding.
It's 25 MM 3046 is the new case.
I'm not sure if the state would be able to speak with the misdemeanor prosecutor in that case, and if we could include it in this plea agreement. I'm not sure if that's an option.
It is an option,
Okay.
not right at the second,
Okay.
Okay,
So,
so,
because I also have to speak with the victim unless the misdemeanor prosecutor has. I've reached out to the victim and haven't gotten a return call, and I think because he doesn't have a voicemail, but
if I may pass Ms. Dotson's case, we did
Yes.
conduct depositions in this case, and we did speak with the alleged victim, who's, of course, the alleged victim in the misdemeanor as well.
yes, well,
So if I could just speak with the state about this one, and maybe we can resolve the misdemeanor as well, that way everything would be
done.
taken care of, yes.
So, Ms. Dotson, what we're going to do is we're going to bring you back out in a little while. It might be after lunch, okay? All right, the attorney's going to work on it.
The other ones are other institutions, so they're not here. And then
Yes, we could maybe address one of those if you wanted. Your Honor, I have a client who's at another institution.
Yes,
I have a couple, actually.
okay,
On the docket who are at other institutions I could address now if you'd like. Or we
yes,
could handle other,
okay,
all my other in-custody ones, I need a minute for the plea agreements.
that is fine.
I have Jamal Ferguson and Javion Sharp.
Okay, let's call Mr. Ferguson's case, and let me just get to that.
Jamal Ferguson has two VOP cases, 22 CF 0017 and 22 CF 258. He is held in another institution. At this point, Mr. Ferguson has indicated that he would like to admit the VOPs and set them for a sentencing hearing. So my office will be in contact with your judicial assistant to schedule that sentencing. And I've informed Ms. Herndon, she's the state attorney on these cases.
Okay.
Yeah.
Are we setting a plea today?
We're setting off sentencing, so my assistant will just have to email.
Okay.
He's just admitting the VOPs, but he's not here because he's involved.
From what I was relayed, he was supposed to be admitting
Yes.
today.
Yeah, so, Your Honor, I apologize that bless you. Mr. Ferguson was not able to be transported today. He is in another jail,
Yes.
and I didn't have time to put in the order to transport him.
That's fine. Yeah.
So I'm not sure if we want to put it for the December date. I'm not sure if we can schedule it for a date and he can admit and we can have the sentencing hearing on the same date. That would be, I would like to do it that way. That way he doesn't have to be transported back and forth multiple times.
Okay,
So if my assistant can contact your office to schedule it that way, or we could pick a date now, I suppose.
how long are you going to need for the sentencing?
No, I know. I don't think we'll need that long, an hour, at most,
Probably an hour, Your Honor.
Okay.
at most.
Let me just check something.
You can? Yes. What about Carl?
Nope, I've printed that one, I have to write that one. I've printed that one, but I have to get it.
Sure.
Printed that one, but I have to get it.
Sure.
Sorry.
One more Carol.
Yes.
Okay.
I apologize.
So I have, it looks like I've got a date, December the 4th. I have a VOP evidentiary hearing with Ms. Gaynor and Mr. Harper from 9 to 10,
Which day is that?
This Thursday, December 4th.
December 4th.
What's the last name of that case, Your Honor, Mr.
Osborne?
Okay. That might be.
I've got the case number.
No,
It's-
Your, me, actually, me and Ms.
Your Honor, I apologize, I'm just signing the plea agreement myself.
All right.
Yeah, she's got it. I'm gonna try. Okay, yeah. Okay. Okay. I was just going over, there were a couple handwritten edits to the plea agreement. I wanted to make sure that Mr. Callaway was aware.
All right.
Okay, we've gone over those, and I have the score sheet as well.
Thank you. Thank you so much.
And I'll give you a copy of the plea agreement.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. Could you state your name, please?
Jonathan Callaway.
Thank you. In case 25 CF 1290, you're charged with one count of battery on a person 65 years of age or older, which is a third-degree felony, and that carries a maximum of up to 5 years state prison. Have you had a chance to talk to your lawyer about that charge and any possible defenses?
Yes,
All right. Have you discussed the plea agreement with your lawyer?
I have.
Did you read and sign the agreement?
I did.
Is that your signature on the back page?
I believe so.
Do you need me to? Thank you very much.
I signed it.
We'll bring it closer to you. Thank you.
Yes.
Okay, that's your signature? Thank you so much. All right. Do you understand the rights that you give up when you enter a plea?
I do.
Do you understand you're giving up your right to go to trial?
Yes,
Are you entering the plea freely and voluntarily?
I am.
Is anyone forcing you or threatening you?
No,
Has anyone promised you anything other than what's showing on the agreement?
no,
Are you satisfied with the services of your lawyer?
yes,
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
my psych meds,
Okay, does that affect your ability to understand what's going on?
no.
I have a score sheet that shows 22.2 total sentence points. Any objections?
No, Your Honor, I apologize. No objections.
I do find a sufficient factual basis based on my review of the arrest report. Is there any exculpatory DNA that the state's aware of?
No, Your Honor.
Okay. Sir, if you're not a U.S. citizen, do you understand that the plea will likely subject you to deportation?
Yes,
How do you plead to count one?
no contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, the court will withhold adjudication of guilt, excuse me, and place you on probation for 24 months. There are some special conditions, and those include no contact with Otist Flournoy, Ottist Flournoy, and you must complete an anger management course and any recommended treatment within 60 days. The court will reserve jurisdiction to award restitution for a period of 180 days. Let me check on the court cost. Is it $967? $867. All right, the court costs are $867 plus $150 cost of defense. That includes the application fee. Did I cover everything?
Your Honor, I neglected to include in there waiving the cost of supervision if state probation is amenable to that.
No objection.
They'll allow him to pay the court costs.
Okay. Are you employed, sir?
No, not right now.
Okay.
He's been at the jail since June.
Okay.
So he's not currently employed.
Okay.
And the anger management course also costs.
Okay.
So if we waive that cost of supervision, we'll allow him to. pay the other costs.
All right. Well, I absolutely want the court costs paid during probation then,
Yes.
because if you're getting a waiver of cost of supervision, then that money needs to go towards your court costs and your anger management fees. You understand?
Yes, ma'am.
Okay. All right. And of course, if I end up awarding restitution, that too.
Yes,
So,
of course. And I've provided Mr. Calloway a copy of the plea agreement as well.
all right. So, sir, first of all, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Second, you need to see Officer Doobie before you leave the courtroom. He's sitting right over there. And then, once you get out, is this the only thing holding you in jail?
Yes, Your Honor.
Okay, so you need to be at probation before 9 o'clock tomorrow morning to check in. You should get out today, I would hope.
Where to go? Yeah.
Okay? Thank you.
I will take my-
Thank you so much.
I don't know where Steve is.
All right, who is next up?
So I was just informed that Mr. Medina is now re-talking to his clients, so we asked if we could see a few of them right now, because Mr. Gates' clients aren't upstairs just yet, so.
All right. Let me ask about a couple on the docket. I'm just trying to figure out whose cases they are. They're listed under Mr. Cochran. Both last names start with M, and I'm not sure who actually has those cases.
Your Honor, I know Mr. Medina has Ms. Kayla Miles.
Ah, okay. Oh, and you know what? I wrote him down for Mr. Sean Moose as well.
And Mr. Medina has Mr. Moose as well.
Okay, so, here comes Mr. Medina.
I'm ready. What do you want? Whoever.
Except for Broom.
Oops.
Anybody but Broom.
Okay.
Thank you. Broom did not resolve 25 million. I just need to write that out based on what we already told. So it's just a minor.
Yeah.
I didn't mean to raise my voice, Your Honor.
All right.
Kayla Miles.
All right, thank you. That is, Ms. Miles's case number is 24 CF 2802, and she is present.
With Ms. Kayla I. Miles.
Yes.
She has 3 cases, 24 CF 2802, 25 CF 1144, 25 CF 1225. I was just informing her, and she was informing me of her position on the state's offer, which is a lengthy jail sentence. We want to talk about that some more, and I'm asking to please let her continue to some time. We'll enter a denial for purposes of today.
Okay.
I don't think it's going to require a VOP evidentiary. Can we continue to mid-December?
Let me see when the new cases are scheduled, and we'll try to get everything on the same day.
Okay. I think they're all the VOPs.
Oh,
I think they're all, there may be something on the paperwork that didn't list all three cases, but all three cases are VOP cases, right? That she has in Okaloosa County, Judge. They're not new law.
well, there are 2025 cases, I'm just checking, and they're not coming up under that number. Okay, having a hard time bringing them up.
Yes, and in fact, it was confusing to me because, but I did look it up. I think I confirmed it correctly. The violation report only referenced 24 CF 2802, and that's the only file I had. But when I looked at the actual agreements, it looked like there were 3 cases rather than 1. And the amended affidavit violation of probation, which only listed 1 possession of controlled substance, I think that's probably incorrect because that clearly states 3 docketed cases.
Yes.
On the amended affidavit VOP. So those, all 3 seem to be open VOPs.
And I'm looking at the order of probation, and it has all 3 case numbers listed, and it's count 1 on each of those cases, and it's the sentence was 36 months probation on each case, each count concurrent. So
they all need to be resolved.
all 3 cases, yes, I'll
Yes.
read them out. It's 24 CF 2802, 25 CF 1144C, and 25 CF 1225C. All are VOPs.
And Your Honor, she would respectfully enter denial and ask for a brief, not super long continuance.
Okay, let me see when, if,
Prefer to not hold it to January. We'd like to get back in December.
I don't even see a warrant in 25 CF 1225. There's an affidavit, but no warrant, and let me just take a look at the other one. I see an affidavit. I do not see a warrant in 25 CF 1144. Mr. Doobie, I believe I'm going to need a warrant in those 2 cases. 25 CF 1144 and 25 CF 1225. And the affidavit that was filed, it's an amended affidavit. It was filed on September 11th. It does list all 3 case numbers at the top, but then it only has 1 listed a little bit farther down, so that's why I guess the warrant was only issued in 24 CF 2802. So I think the affidavit, I don't know, I'll let y'all figure that out, but I definitely need a warrant in the other 2 cases if there's an alleged violation in those. But you'll see when you look at the amended affidavit. Thank you.
And Your Honor, just for the record, the state's offer is 1129 jail.
Okay.
And there doesn't appear to be any willingness from the state to come down, but I still want to have her continued over rather than taking it today. There is my understanding, there's a still open drug paraphernalia case in Walton County. I'm advised that well, it's still open. So she was gonna plead to the grounds 2 through 4 and keep that open, but it's all kind of moot right now. We'll just see where things are headed.
Okay.
If there is a date to continue it to.
Oh, yes. Just making a note, December 16th at 9, and there will be a warrant coming on the other 2 cases. They're supposed to be included, but only the one case was listed in the affidavit, even though they're all 3 at the very top. So there's going to be a warrant coming in the other 2 cases.
That's fine. So we needed to come back and have a bite at those other 2 cases anyway, but can we do the denial on all 3, or? It's really splitting hairs because
I know.
she's coming back December 16th either way, so.
Hopefully, I'll have a warrant and should be able to be processed and served, and then we can take care of everything, whatever we need to do to address all 3 on December 16th. But maybe only enter a denial on the one, since there's only a warrant in that one.
Yes, Judge, and because I didn't have her file yesterday when I went to the jail, I got it when I got back. She's not had a chance to talk to me out of the courthouse, so we'll need some more and see what we can do.
Okay.
Thank you.
Sure. So December 16th at 9. I don't know if I can even set the other 2. Am I able to set the other 2 if they're just? Okay, great. So we're putting the other 2 on the docket for a status right now.
Sure.
I mean, that'll change, once the warrant is served, or signed and served.
Yes,
But
Judge.
right now, we'll try to get everything on the docket for December 16th, so everything can be addressed at that time.
Thank you very much.
Sure, 9 o'clock that day. Thank you.
Rapping Tiffany's up next.
Your Honor, Tiffany, I think it's D. Bracken, if I'm not mistaken. Tiffany D. Bracken is before the court in 24 CF 942. And just for the record, with us in court today is her friend, it's Ronald Owens, right? Mr. Owens, we're just putting on the record that he's present in the courtroom, and I would ask him to come forward, not all the way, but to where everybody can hear you clearly stating your address where she's going to be living. Come forward more.
Yeah, actually, he needs to get near a microphone
Okay.
because the court reporter won't be able to hear. Sorry about that, sir, but I have to make sure that the court reporter who's listening to us can hear you.
Okay. It's 8101 South McCann Road, Southport, Florida, 32409.
And McCann is MCCANN,
Yes, sir.
and Southport, SOUTHPORT, one word?
Yes, sir.
Okay. And I know that's in Bay County, right?
Yes, sir.
Yeah. Okay, thank you.
And could you state your name one more time, sir?
Ronald Owens.
Thank you.
Okay, you can sit back. Your Honor, if I might approach with an agreement, and it is for a reinstatement and modification
Okay.
of, so there will not be a adjudication of guilt and a score sheet. However, the state may want to, the court may want the state to put on the record. Can you tell us where we are on the score? If it's not too much trouble while I'm approaching.
Sure, and is the Okaloosa County Sheriff's Office transportation included in the agreement?
Yes,
Okay.
the state was way ahead of me on that and did write that in.
Wonderful,
May I
thank you.
approach?
Yes, thank you.
And
Thank you so much.
Judge, I need to be showing this to probation too. I apologize to probation. There were a few of them I wrote up by hand. So it may be helpful if I go back and let you
Sure.
make a photo picture. Sorry.
No problem.
As far as her score sheet goes, her total sentencing points right now with the VOP is 20. So she does not have a lowest permissible yet.
And Judge, I apologize. I got ahead of myself. She's signing the agreement that we've been over.
Okay.
state has to sign too, Your Honor. What'd you say, that's not that score one?
Her total sentencing points are at 20.
Okay.
So she doesn't.
May I approach, Judge?
Sure. Thank you very much.
Hopefully the court can read my handwriting.
I can, thank you. All right, ma'am, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. You can put your hand down if you'll just state your name, please.
Tiffany Bracken.
Thank you. In case 24 CF 942, it's alleged that you violated your probation. In fact, it's alleged you violated your probation within, about a week after you entered your plea, back in April. And there are 8 allegations that you violated your probation. This is in the VOP affidavit filed on May 15th, 2025. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, Your Honor.
Okay. Have you discussed this plea agreement with your lawyer?
Yes.
Did you read and sign the agreement?
Yes.
Is this your signature on the back page?
Yes, Your Honor.
Do you understand you're giving up your right to have an evidentiary hearing to make the state prove the allegations?
Yes.
All right. Are you admitting the violations freely and voluntarily?
Yeah. Yes.
All right. Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing on this agreement?
No.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No.
All right. I accept your admission. I find it was freely and voluntarily made in accordance with your agreement. The court will reinstate and modify your probation. You will maintain your withhold adjudication. Let me just put this out there that if there's another VOP, I may not be inclined to agree to another withhold.
The state won't be offering that, Your Honor.
Thank you. Based on how quickly there was a violation and the number of violations. So there's a special condition this time, this is the modification, that you must spend 90 days in jail with credit for time served. Looks like you were arrested a couple of months ago. You may be getting close to having completed that sentence of the special condition.
I did look it up, Your Honor. Obviously, I'm not providing definitive advice. Would the state stipulate she has 90 days in? And it looked like she had, okay, well, it'll be up to the jail to compute.
Yeah, whatever the jail determines your credit is, then that's what it'll be. But I know that you've been in there for about 2 months at least from what I can see, but it's up to the jail to count the days. You'll get, whatever the credit is, you'll get it. Then, let's see, you must complete the original requirements. There are additional costs and fees included that are in addition to anything that was previously imposed. There's a $100 violation of probation cost of prosecution fee, $150 cost of defense, that includes the application fee, and transportation costs to the sheriff's office, Okaloosa County Sheriff's Office, in the amount of $166.62. Did I cover everything?
Yes, Your Honor.
All right. So, ma'am, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you. And you need to see Officer Doobie before you leave the courtroom. He's right over there. And then you need to check in whatever day you get out. The next business day, you need to be at probation before 9 o'clock in the morning. Okay?
Okay.
Good luck, ma'am. Thank you.
Moose is up next.
Good luck, Moose. or Steve Medina with Sean Moose. Mr. Moose is before the court in 20 CF 1814. And I'm just grabbing the file, Judge.
Okay.
The score sheet on Moose. Did you give it to him? Because you wanted an adjudication. Wait, do we need, no, we're not revoking and terminating, so we don't have to have a score sheet.
I've got one just in case.
Yeah. Let me take it, thank you. Your Honor, it's not going to be a revoke and terminate under the agreement, so there technically doesn't have to be a score sheet. He was already advised of what the score is, and it is, because it's going to be a reinstatement and modification, there will not be a lowest permissible prison sentence, but there would have been a 17.775 lowest permissible prison sentence in months if there had not been an agreement worked out for a reinstatement and modification. Basically, the state will, I think, represent that based on victim request, because of restitution, the state wants to give him some more time. So that's what the agreement is I'm going to be approaching with. He is signing the agreement, Your Honor.
Okay.
That's
Thank
correct,
you.
Your Honor. The state's initial offer was a guideline sentence. That's actually what I sent Mr. Medina yesterday afternoon. The victim then called me back after I sent my offer. And it's really the victim's request is why we're reinstating. They would like their money back. So,
Thank you. Thank you. Is the transportation cost of $99.56 included for Okaloosa County Sheriff's Office?
Your Honor, if not, we will add that. May I just,
Sure. There is an affidavit of costs filed on October 3rd.
so I'm just going to put COT for cost of transportation. What
Sure.
would that amount, Your Honor?
$99.56. It was transport from Escambia County Jail to here.
You see that? Yes, sir. Okay. Your Honor, may I approach?
Yes.
Oh, I'm sorry. There were several that I wrote out at the last
Okay.
minute, so I need to have probation
All right.
make a photocopy rather than me give them a hard copy.
Sure.
The good news is we're getting a lot of cases resolved.
Yes.
Thank you.
That's great. In light of the size of the docket today, that's great. Thank you.
May I approach, Judge?
Yes. Thank you so much. All right, sir, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. And could you state your name for me, please?
Sean David Moose.
Thank you. And you're here in case 2020 CF 1814 on allegations that you violated your probation. I'm just checking something real quick.
When you get a minute, can I inform the court of one other thing?
Sure. Okay. I think there could be an error in the probation order, but I'm checking. The probation order only says, it says probation is on count 1 and 3 through 5. I'm looking at the order of probation entered on March 18th, 2022.
And it was clearly adjudicated guilty as to it was a withhold, but it was to all cases and all counts. including
Right, so count two is
Right.
missing on this order.
Right.
I saw I was looking at the plea agreement from back in February of 2022, and it was to all 5 counts.
I see it here over to the right of the charges.
Oh, you're right, I didn't see it there, thank you. It's off to the side, that's why I was looking up and down. Thank you for that. I'm mistaken. Count 2 is there, it's just off to the right.
Thank you, Your Honor. Your Honor, may I
Thank
put
you.
one
Sorry to probation for thinking they got it wrong and made a mistake. I was wrong.
I
Yes,
just
go
wanted
ahead.
to also inform the court one thing, because the court may be wondering about this situation. Mr. Moose, his father did provide, and we provided to the state, proof that while he was in the absconder status, he was making major steps to regain his sobriety and did pay for his own inpatient drug treatment program, which he did complete. I think it was the Oxford facility in Mississippi, and he got various certificates of achievement and so forth. So he did royally mess up in not remaining in contact with probation, but I did want the court to know he was making efforts to regain his sobriety.
Thank you. Thank you for that. All right, so, sir, there's an affidavit filed on October 8th of 2024. And it contains 5 different allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations and any ways you might have to fight the case?
Yes, ma'am.
All right. Have you discussed this agreement with your lawyer?
Yes, ma'am. Your Honor.
Did you read and sign the agreement?
Yes, Your Honor.
Is that your signature on
It
the
is.
back page? Okay, thank you. Do you understand you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes, ma'am.
Is anyone forcing you or threatening you to make you admit the allegations?
No, ma'am.
Has anybody promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Are you freely and voluntarily admitting the allegations that you violated your probation that are in the affidavit of October 8th, 2024?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, there will be an adjudication of guilt on all of the charges. Probation will be reinstated and modified with 18 months additional supervision, concurrent on all counts. And so we're extending the original term by 18 months on all counts concurrent. And it says here, the probation may be served in Mississippi if approved under the interstate compact. So you have to go through that process with probation, and then they'll tell you that you're free to go to Mississippi, that you've been approved, okay?
Yes, ma'am.
You must still complete all of the original requirements. And in addition to any previously assessed fees and costs, the following additional costs and fees are assessed. $100 cost of prosecution fee, $150 cost of defense, that includes the application fee, and $99.56 cost of transportation to Okaloosa County Sheriff's Office. Did I cover everything, Mr. Medina?
Yes, Your Honor.
All right. Sir, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. And Mr. Doobie.
Your Honor, just a point of clarification, so his original scheduled term date was October 1, 2025. So is that 18 months going to be from today's date or from the October 1st date?
I had that question too.
I think it would be,
Today's date.
it's fine to be from today's date because there's enough time to accommodate that, if that was the intent.
That was my intention.
Okay, so it's 18 months from today. Let me make a note of that.
The one concern I had is because it was reinstatement and modification rather than a revocation. I think there would be an automatic continuance when the VOP had been served, so we're probably okay running it for today. I just don't want there to be any implication that he was terminated due to the October 1 passage.
I think once the affidavit is filed, that tolls
Tolls everything.
everything.
So I think we're fine.
Okay, and that was filed back in October
Right,
of
over a
2024.
year ago.
Yeah.
Yes, yes.
So, okay. So extending 18 months from today.
Yes, ma'am.
Okay. So, sir, you need to see Officer Doobie right over there before you leave the courtroom. He's sitting on the front row. Yes, and once you get out, you'll need to check in. Is this the only thing holding you in jail? You should get out today then. But you need to see Officer Doobie first thing in the morning before 9 o'clock, and you can't go to Mississippi until probation tells you you need to go, or you're okay to go. Good luck. You have 30 days to appeal. If you can't afford a lawyer, I'll appoint one.
This is Donnie Atkinson.
Okay.
Your Honor, Donnie M. Atkinson is before the court in 24 CF 2926, and he is signing the agreement that we've worked out with the state.
Okay.
And I'm going to give probation a copy of this one.
And we probably, Mr. Medina, need to take a lunch break soon. I'm not sure how many, I know that Mr. Cusimano has been sitting here for a while, so I'd like to.
address this whenever. I was
hoping Yeah.
we could do that before.
I would like to do that before lunch so he doesn't have to come back.
It'll be very brief.
Great, thank you.
Just keep that one, we'll sign this one, because Rachel's already signed this one. It's the same. Yeah. Sign it there instead. And it's a reinstatement, Your Honor, so there
Okay.
is no short. May I approach?
Yes, thank you. Thank you so much. All right, Mr. Atkinson, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir.
Yes, ma'am.
Could you please state your name for me?
Donnie Maurice Atkinson.
Thank you. In 24 CF 2926, it's alleged you violated your probation.
Yes, ma'am.
There is an affidavit that was filed on September 22nd. It has 2 allegations. Have you had a chance to discuss those allegations with your lawyer?
Yes, ma'am.
Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
All right. Do you understand the rights that you give up when you admit to the violations?
Yes, ma'am.
You understand you're giving up your right to have an evidentiary hearing?
Yes, ma'am.
Have you read and signed this agreement?
Yes, ma'am.
Is this your signature on page 2?
Yes, ma'am, it is.
Are you entering the admission today freely and voluntarily? All right. Is anyone forcing you or threatening
ma'am.
you? Has anyone promised you
No,
anything?
ma'am.
All right. Are you satisfied with your lawyer?
Yes, ma'am.
Are you admitting both of the allegations in the affidavit?
Yes, ma'am, I am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, there's already been an adjudication of guilt on the underlying charges. I do find that you have violated your probation based on your admission. I'm reinstating and modifying your probation. The next 6 months will be on community control, followed by the remainder on probation. So we're not extending, let me just make sure, we're not extending the length of time, we're just converting the next 6 months to community control, is that correct?
That's
or-
correct, Your Honor.
Okay,
And then followed by the remainder, the balance, in my understanding, continues all the way out into 2027.
okay. And you must still complete the original requirements, and there's an additional special condition of weekly NA or AA meetings at Emerald Coast Life Center, is that what that is?
That's correct, Judge,
Okay.
I'm sorry, I didn't write.
No, that's
that down.
okay. ECLC, Emerald Coast Life Center, for the next 60 days. So for the next 60 days, you got to go every week
Yes,
to a
ma'am.
meeting.
Yes, ma'am, I've been doing that anyway.
Good, good. Then these are additional fees and costs that are imposed on top of whatever's previously been imposed. $100 cost of prosecution, $150 cost of defense. That includes the application fee. And sir, good luck to you. You have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. See Officer Doobie before you leave. And then you need to be at the probation office reporting in tomorrow before 9.
Yes, ma'am.
Is this the only thing holding you in jail?
Yes, ma'am.
All right, you should get out today.
That's it. Yeah, I was planning on going and take care of all that today.
And he lives in Crestview, right?
Yeah.
But does he need to report it in Fort Walton Beach at least for check-in today?
Okay, if you can get there today, but I doubt it.
If
But
not by 9 o'clock in the morning, correct?
Correct,
All right.
yes.
Yeah,
Good
that's
luck,
fine.
sir. Thank you.
Thank you.
Thank you.
I'll sit back.
All right, Mr. Cusimano is next, and let me call the case. That would be 25 CF 2043, and sir, if you could just state your name, please.
Mark Anthony Cusimano.
Thank you. Okay?
Your Honor, the state is stipulating to a change in the bond condition from no contact with the victim to no violent contact with the victim. Gwendolyn Cusimano, state did speak with her today, actually, and she would like no violent contact to be imposed.
All right.
So if we could, I guess, put his case on for the next pretrial conference date, December 8th. Yeah, in the meantime, we'll have that condition of bond modified.
The court
we need to
ratifies.
Oh, I apologize.
No, I think if you put it in the minutes, is that good enough? Or do I have to do an order? Okay. The court will ratify the stipulation and modify pretrial release from no contact with the victim to no violent contact. Now, sir, no violent contact means no yelling, no
Yes, ma'am.
shouting, no threats of violence, no acts of violence. You can't commit a violent act on a,
Yes, ma'am, I know.
on another object in the presence of the victim, like breaking something,
Yes, ma'am.
slamming something. I'm just giving you
Yes,
examples.
ma'am, I've been
All
married
right,
30
that means
years. I know.
peaceful, courteous
Yes, ma'am.
interaction.
Yes, ma'am.
No threats over the phone or text or any other method.
Yes, ma'am.
Okay?
Yes, ma'am.
So your next court date is December 8th.
Thank you. December 8th at 9.
Yes, ma'am.
Stay in touch
Thank
with Ms.
you.
Farkas.
Thank you, ma'am.
Thank you. Good luck to you, sir. Thank you for your patience today. Oh, he's currently scheduled for February. Do you want- Oh, Mr. Kuzmano, hold on just one second. Do you want February or do you want December, Ms. Farkas?
Let's put it on let's keep it on the February date. That'll give the state and defense time to
Okay.
maybe work something out.
And if you would like to bring the case in early, if y'all reach a
Absolutely.
resolution, you know that I would be thrilled to take an early plea.
Yes.
So we
Hold
will
on, let me just.
forget the December date. We're keeping it on February 9th, I think.
I think it's the 9th.
9th at 9 o'clock, February 9th.
There you go.
9 o'clock. Stay in touch with Ms.
Okay, thanks.
Farkas.
Yes,
Okay?
ma'am. Thank you, ma'am.
Thank you, or whoever is going to be covering for her.
Yes, ma'am.
Thank you. Okay, so it is 12:15. We have all been sitting here without moving for quite a long time, and it's lunchtime. So I do see someone in the,
She's here for Robert
oh,
who's not being seen till after.
okay. So unless there's something urgent, we probably should take a lunch break.
Yes.
So we'll see everybody back in an hour,
Thank you.
okay? And then we will carry on.
All right, please.
Thank you.